Well, hello, everyone, and welcome to One Civil Law. I hope you're having a great day as the Karen retrial is coming to an end. Today, we have the charge conference in which the parties will argue over the formal legal charge to be given to the jury, the instructions. This might be fairly quick, all things considered, because the charges, of course, are the same as they were in the first trial. And so obviously we have done a lot of that work already. And so some of that language may be fairly easy. Of course, the big question for yours truly is what the defense will take, what position the defense will take on the question of partial verdicts, right? Because that would be the question I want to know the answer to, right? And if it were up to me as the judge, I'd be like, this is the time you have to decide. This is the time, right here, right now. You have to pick a side, right? You can't wait until like the jury's been deliberating and you sort of feel it out with your tea leaves and your entrails, and they send you a note, whatever. Like you've got to eat this one way or the other, and you've got to eat this now, not knowing anything. What do you want to do? Do you feel lucky, punk? And so forth and so on. So that would be the question I want to know as the judge. And as the judge, I'd also be like, defense, it's up to you. This is 100% your call. We'll do it either way you want. Do you want the partial verdicts or do you want the complete verdicts? But you have to tell me now, and you can't change your mind. So what do you want to do? What do you want to do? And I don't think the defense is going to do it. I don't think they're going to do it because partial verdicts, obviously, well, I don't know necessarily, obviously, I don't know. There's probably studies and law reviews on it to be sure. So perhaps not obviously, but I think that generally speaking, it probably favors the prosecution. Because it allows the jury to not have to solve everything, right? They can be like, we figured out one thing, good enough, call it a day, right? If they have to solve everything, one way or the other, whatever it is, like even if they're split or inconsistent verdicts, if they have to solve everything, that's more work. If they know that they don't necessarily have to do everything, that's easier, and easier might suggest a bit more ability to compromise. Why don't we just agree to like the lowest count of manslaughter and blah, 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 right? It's so like, I think it probably favors the prosecution. I assume there's academic studies on this. Maybe we can ask Google Scholar and see during verdict watch. That's something we can look up, and we can see what the scholarship is and see if my intuition backs the scholarship or not. We can learn something either way. That'd be fun. And we'll go from there. So we will see. Let me pull up the stream, or at least get it ready for us. In any event, so this might be fairly quick, all things considered, because there might not be too much to discuss. There is, of course, a motion for directed verdict, which of course will be denied, as we all know. Which incidentally should be denied, and we'll discuss that a little bit more in just a second. But the charge conference may be fairly simple, and then they're off to, prepare prepare their closing arguments. They'll probably get their hour 15. They'll probably get their hour 15 each. I don't really have a strong problem with this, by the way. Like, with time limits for opening and closing. Once again, if I were a judge, time limits for opening and closing sound like a really good idea. Make it work. Make it work. I don't need you to talk about war and peace for 8,000 years. Make it work. Figure it out. So I'm not necessarily opposed to the hour time limit. It might be one of the few things from Judge Bev that I like. It's like, you can only have an hour. Fuck you. So yeah, if we could bring them back time limits to other parts of the trial, I'd be in favor of that too. Chess clock, of course, for criminal case. And again, something we can look up during verdict watch. We can look up about chess clock in criminal cases. I think it was, I seem to vaguely recall reading a Court of Appeals decision once in which there was a chess clock. The defense ran out of time. The judge refused to allow them to cross-examine witnesses because they ran out of time. And the Court of Appeals said, no, you can't do that because of right of confrontation. And as I vaguely recall, though, they said, like, the right of confrontation doesn't have to be much, though. So the judge, the way I remember reading it, implied that the right of confrontation could be just like a couple questions. Like, okay, you ran out of time, so you get 5 courtesy questions. Make them count, right? But we could look up some case law and see what's going on in that domain. That could be fun. If partial verdict, can she be tried on charges that have no verdict? Yes. Yes. So this can be done in multiple different ways, right? If you do partial verdicts, you can also accept verdicts, enter them, and send the jury back to deliberate on verdicts they haven't done. So just because they can receive partial verdicts and just because the judge accepts the partial verdict doesn't necessarily mean the jury's done, right? Because you can do that too. It's like, okay, it's guilty or it's not guilty as the case may be. I accept that verdict. I enter that bad verdict. Now go back and figure out the rest. You can do that too. So you can do this in phases. And obviously you can retrial on anything for which there was no verdict, obviously. Just Clock Sync Fun, thank you very much, Julish. Or J.E. Walsh, as we sort of remembered. It's not Julish, it's J.E. Walsh, even though it confuses me. You want to talk insurance when we have a chance? Did you figure out our moon insurance thing? Are we doing the moon insurance thing or what? Where's my moon insurance rider? Where is my moon insurance rider? Where is my car suddenly winds up in space rider? I want my rider, damn it. Where's my rider? God damn it. Give me my insurance. I want to be insured against sudden, my car suddenly winds up in space. I have concerns and I want to be insured. Like a good neighbor, State Farm is there. Give me some goddamn insurance. You can only cover me if a piece of moon debris falls on you? That's less likely, actually, than, well, actually, I'm not sure if it's strictly less likely or not, but moon debris falling on me, that's, yeah, not gonna, okay, that's not gonna happen either. Yeah, even if a piece of the moon broke off, it would just remain in orbit. And to the extent it didn't, it would tend to go like out because the moon is receding from the Earth very, very slowly. So the momentum is out. No. We're just talking about the car spontaneously winding up in space. We are not talking about any sort of boosters or space rockets. We're just talking about, because he said it's possible. Anything's possible, remember? He said it's possible, could wind up in space. So I want to be insured against, I'm going backwards 25 miles an hour in my car, and suddenly my car's in space. That's what I want to be insured again, because apparently it's possible. I'm not sure how the risk adjusters are calculating the probability on that one, but let me help you out, risk adjusters. The probability is 0. So it's a really good deal for you because it's just free money. Your insurance against something that's impossible, but he doesn't seem to think so, but that's okay. I want a collision rider. No, not a collision rider. This is not a collision. My car going backwards at 25 miles an hour and winding up in space is not a collision. It's catastrophic in every sense of the word, but I'm not sure it's covered under a catastrophic policy. And, I'm not really sure about acts of gods and stuff like that. I want a goddamn rider. I just do not, look, I'm paranoid. I'm paranoid insurance company, you understand, right? I am just not satisfied with the standard language in the contract, okay? It's just not good enough for me. I just need an explicit rider that covers my car winding up in space, okay? I need a declared policy. I need to be very clear, notwithstanding any other provision. If your car winds up in space, we will cover you. That is what I need. I need that. Put that in writing. God damn it. Yeah, catastrophic, especially if you're in the car when in space. Yes, it's like it's catastrophic in every possible sense. Yeah, every possible sense, including new and exciting senses of the word catastrophic. That is how catastrophic it is. It is, we have reached new and exciting senses of the word catastrophic in this scenario. Yeah, catastrophic doesn't even begin to really cover it at that point, to be quite honest, but yeah. Low rider drives a little slower. Boop, 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 boop. Boop, 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 boop. Is it coming back or a one-way trip? If the Lexus comes back from space, it's probably not going to be intact. So I think we should just consider it a total loss no matter what happens at that point. Regardless of whether it comes back in space. If somehow it winds up back here intact, then I guess I just get the cost of the car for free. Although having been written off completely, I guess now you're the owner of the car legally because you've paid for the car for a complete loss. So I guess as the car comes back now, you're just the owner of the car. Congratulations on your car ownership, I guess. Yeah. The car surviving, you know what, to be fair, the car surviving re-entry is more possible than the car winding up in space in the first place. I mean, you know, depending on how the car re-enters, maybe there won't be that much friction. Maybe it'll be okay. It's still more possible than the car winding up in space in the first place. I'm not sure what the possibility of the Lexus surviving a re-entry is, but it's still more possible. You know, if the car re-enters just right, you know, and it's got to be more possible. It's got to be more possible. Yeah. Yeah. Also, the insurer is going to be happy because of the space car, right? Yeah. How much that goes for at auction? That's a good point, man. This car went to space and back. That's got to be good for an auction. So not only do you get the car, you actually get to auction the car, and there's got to be some people that want to buy that car. Although you're going to have to sell it with one hell of a waiver. You're going to have to sell it with one hell of a waiver, a disclosure statement. That's going to be one hell of a. It's going to be one hell of a, you know, listing of known faults. You know, you got to make the customer aware of known faults like that. I'm not, again, as your lawyer, I'm not sure simply stamping as is will be enough protection for you. Yeah, I'm not feeling it. Your lawyer advises you that as is just not going to cut it in the scenario. And if the car has a possibility of winding up in space, you're going to really need to disclose that one. Please, clearly, unambiguously, repeatedly, in very big letters. Yeah. Yeah. As is not cutting it on this one. Sorry, guys. Yeah. No. It's just no. Yeah. No. Yeah. This is great law hypothetical though. This is fun. Will the odometer be reversed while in space? Well, the odometer only covers distance traveled on the road, right? So going up to space and back doesn't count. So you don't have to change the odometer for that. And I think it would be actually illegal to change the odometer for that because that would be tampering with the odometer at that point, and that would be illegal. So, yeah. Yeah, I don't think you have to put it on the odometer. Although you can feel free to disclose it separately. Put a little asterisk by it. Does not include, space travel distances. That'd be fine. Yeah. Yeah. What law in there in space about tampering with an odometer? What jurisdiction is that? Good questions. Well, I don't know necessarily. Well, first of all, to the extent that US law applies extraterritorially anyway, then it would apply in space too. Also, space is typically governed under maritime law principles. So there's that. But unfortunately, legal vices, our heart goes out, is dead, which is very sad. So we cannot ask legal vices about the maritime consequences of the magical space Lexus, which is disappointing for us all. He was our maritime expert. So, yeah, I don't know. Yeah, I don't know. Yeah, in terms of there not being a rebuttal case, the only thing that makes sense is that he didn't have anything particularly strong to say. Right? He didn't have that, dynamite witness that was just going to blow the entire case apart. We never heard from the dog behaviorist expert. After all those motions to bring in the dog behaviorist expert, the trainer guy, we never heard from him. It's very disappointing. Is a directed verdict motion one of the things that's just always done? You better bet your ass. You better bet your ass. Yes, you always do it every single time. It is very pro forma. Yeah. If you don't do it, you're kind of a bad lawyer. I've seen lawyers not do it. We've seen them not do it on stream, and I've been critical every time. You always do it. Even if you have to, hold your breath while you're doing it. You always do it. Of course you do. Not for at least the reasons that, of course, you need to preserve options and appeal options and stuff like that. So you need to do it for, if no other reason, than preserve potential issues on appeal. So all those reasons. Did I see your question? I don't know. I'm just kind of doing what I do as I do. Ask it again. Maybe I'll see it the second time. We'll see. MG Law, how are you doing? You want to just hop on stream for a little bit or something? I miss you, brother. Maybe you know something about maritime law and can help us about the implications of changing the odometer when the car is in space. You got anything on that point? Yeah, you hold your nose and make the case. Yeah, You're a lawyer for Darrell Brooks. You are Darrell Brooks in that case, I suppose. You're a lawyer for Taylor Business. You're a lawyer for Sarah Boone. Of course you make that motion. 100%. You make that motion. Yeah, we moved for directed verdict. The state has the burden to prove the case, and they have failed to prove each and every element of the charge. We therefore act for a directed verdict. What elements have they failed to prove, counsel? I don't know. Dealer's choice. What elements do you think they failed to prove? Yeah. Can there be an inquiry into trial after trial? If Hank hid the X-rays, a bar issue, and Welcher lied, perjury? Well, first of all, perjury is really, really difficult for a lot of reasons. Perjury is a lot harder than I think people seem to give it credit for. Perjury is actually a fairly difficult charge. Anyways, relating to the X-ray stuff with disclosures, I suppose there could be some sort of inquiry, but there won't be. They've been disclosed now, so it's all good. I wish I could join in. I know, unfortunately, nothing about maritime other than applies when traveling on land in a motor vehicle and in almost every contract dispute. It doesn't apply when traveling on land. It applies in the sea. That's maritime. What are we talking about? In almost every contract dispute? If every contract dispute involves maritime law, you're doing something wrong, MG Law. I don't know what to tell you, man. How does every contract dispute you involve have maritime law issues?
Was now open. You may be seated.
Good morning, Your Honor. May I call the case?
Please.
For the record before the court is Commonwealth versus Karen Reed, 22 CR 117. The parties are present. The jury is not present. The matter is on for trial. If the parties could please identify themselves for the record.
Good morning, Your Honor. Good morning, Ms. McLaughlin.
That's sovereign citizen? I understand now.
Good morning, Mr. Lally.
Good morning,
Never mind.
Good morning, Mr. Brennan.
I'm sorry, MG Law. I just assumed you meant like real actual law, not made up bullshit law. I'm sorry. But we were talking about made up bullshit space Lexus, so I guess I failed to put two and two together. That's my fault.
Morning, Your Honor. Robert Alessi from Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti from Karen Reed.
Good morning, Mr. Yannetti, and good morning, Ms. Reed. All right, so Mr. Yannetti and Mr. Alessi, you're standing in also for Mr. Jackson and Ms. Little?
We are.
Okay. All right.
What, the entire defense team couldn't be bothered to show up this morning? What bullshit is this? What are Jackson and Little doing? I guess Jackson's giving the close and he just wants the entire day to like sit in a room and just work on his closing argument. I guess. Is Miss Little there meant to assist him? I guess. All right, fine. Never mind.
So first thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence. So it's marked still for identification.
What's excluded? I'm sorry,
evidence.
it's too early.
Thing we left off yesterday was whether KKKK for identification, the PowerPoint of Dr. Rentschler would be entered into evidence. It will not be based on the objection, so it is excluded from evidence.
In some ways, it's not that big a deal, but like,
So it's marked still for identification, and your rights are saved on that. So we ready to go forward with the charge conference?
Yes, Your Honor. I guess I have a question first as to whether the court would like to entertain the argument on the motion for the party finding not guilty of closing all the evidence.
So, no, we can do that now. So now that my ruling is on this, evidence is closed. Evidence is closed as it was yesterday. So go ahead on your required finding argument. Sure.
And this is not lengthy, Judge. 5 or 10
bet it's
minutes.
not.
Take your time.
Thank you. We are renewing our motion for required finding of not guilty at the close of all the evidence, and in so doing, Your Honor, we're incorporating our oral argument in support of this motion that we made at the close of the Commonwealth case. At that juncture, Your Honor, the Commonwealth had produced no witnesses to testify that John O'Keefe's injuries were consistent with his having been hit by a motor vehicle, and if he was not hit by a motor vehicle, none of these three indictments may stand. The Commonwealth, we believe, at that time fell woefully short of proving their case. Now that the defense has put on a case, the Commonwealth's case has been further weakened, such that none of these charges can stand. Nearly every witness, Your Honor, we have called, we would submit, has destroyed the Commonwealth's theory of the case. Dr. Russell testified.
What is the Commonwealth's theory of the case at this point? Seriously. I'm not 100% sure I know what their theory of the case is exactly. it's a little vague to me. I mean, the car hit John O'Keefe, but like exactly when, how, in what way, so forth and so on. Yeah, the details are a little vague to me. Does anyone actually understand exactly what the state's theory of the case is precisely at this point? Or is it just me? Anyone know? Anyone know what their theory of the case is? No? Yeah, I'm a little vague on this. I will point out legally, for whatever it's worth, that they can change their theory of the case at any time, because all they can't do is change an element of the crime. So the theory of the case is like exactly what happened, I suppose, but as long as it doesn't change an element of the crime, they can change their theory of the case at any time. They can, although it makes it difficult for them to like, what exactly are you trying to convince us of is confusing. And to the extent they change their mind, that's going to be a bit of a problem, right? But I guess strictly speaking, they aren't legally required to have a theory of the case, I guess in the strictest possible sense. But it's still kind of confusing. It's like, yeah, I have a case, but I don't actually have a theory of the case. Okay. Yeah, problems are emerging. Pressing on.
Testified for the defense. She's a leading expert on dog bite wound pattern recognition in the country, and she testified about medical injury causation and provided the jury with her expert opinion that John O'Keefe's injuries were consistent with dog-inflicted wounds, both bites and scratches. I would remind the court at this juncture that there was a dog at the very residence where John O'Keefe was found, a dog which was a longtime member of the family, which the family gave away after John O'Keefe's death. A dog which mysteriously was absent from the home at 6:30 in the morning.
Dog's dead.
On January 29th, when Jennifer McCabe claimed that she burst into Brian Albert's bedroom where the dog always slept. A dog which was absent from the home when the Canton police entered the home later that morning. Importantly, Dr. Russell agreed with the Commonwealth's medical examiner, Dr. Scorti-Bello, that John O'Keefe suffered no injuries that were consistent with having been in a motor vehicle collision. And again, if there's no collision, there's no case. Dr. Lopesada, one of the most experienced and accomplished forensic pathologists you could find anywhere, agreed with Dr. Russell that John O'Keefe's injuries were consistent with an animal attack. And she agreed with both Dr. Russell and the Commonwealth's expert, Dr. Scorti-Bello, that John O'Keefe was not hit by a motor vehicle. So the question is, in what type of murder case would a judge ever allow a motion for required finding of not guilty? In a murder case where expert testimony on both sides is that
A motion for required finding of not guilty. Why can't you just call it a directed verdict, Massachusetts? Why can't you just call it a directed verdict like everyone else? A required finding of not, just call it a fucking directed verdict? Jesus Christ. Got to be different, don't you?
that the evidence is inconsistent completely with the Commonwealth's theory of the case. That's exactly what we have here. But it doesn't stop there. Both witnesses from ARCA drove a stake through the heart of the Commonwealth's case. Dr. Wolf concluded that the damage to Ms. Reed's Lexus was inconsistent with having come from a collision with John O'Keefe. Unlike Dr. Welcher, who created, we would submit, a meaningless experiment based on no scientific method, Dr. Welcher actually did the proper force analysis and concluded that Ms. Reed's Lexus was not damaged by the body or the arm of John O'Keefe. His testimony was unimpacted by cross-examination, and it's devastating to the Commonwealth's case. Dr. Rentschler further cemented that there was no collision between the Lexus and John O'Keefe. It is simply not possible that this 6,000-pound SUV hit John O'Keefe at 24 miles an hour and caused only superficial wounds to his right arm with no injuries to his legs or lower body. The SUV did not hit him. John O'Keefe was not hit by the SUV. The case is over. But on top of all that scientific evidence, Your Honor, there were 3 additional fact witnesses who testified for the defense who corroborated that the Commonwealth's theory of the case is false. Sergeant Nicholas Barros, a sworn police officer, testified that when he saw Ms. Reed's SUV that day, before it was towed to the Canton Police Sally Port, the taillight was merely cracked. When he was shown photos of what it looked like in the Sally Port after Michael Proctor had access to it, Sergeant Barros confirmed that it was absolutely different. Karina Kolakithis confirmed that there were no problems between Karen and John O'Keefe that night, even remarking on just how sweet he kissed her on the forehead shortly before they left the Waterfall. But perhaps more importantly, that kiss happened right in front of Brian Higgins, the same Brian Higgins who had been flirting with Karen Reed that month, the same Brian Higgins whom Karen had ghosted for several days before January 28th, the same Brian Higgins who had texted Karen that very night, well, and received no response, the same Brian Higgins whom Karen had given her back to all night, the same Brian Higgins who had to be restrained at the end of the night by Chris Albert on video, the same Brian Albert who is on video, hot, angry.
Brian Higgins. You just said Albert. You mean Higgins, right?
I meant Higgins, yes. Yeah, the same Brian Higgins, who is on video, hot, angry, and gesturing to John O'Keefe to meet him outside shortly before they left the Waterfall and shortly before John O'Keefe was killed. And finally, Brian Loughran, plowing Fairview Road at 2:45 in the morning, was attentive, watching everything in front of him, very familiar with the Albert's residence, and had every reason to protect the Albert family. You recall that he did protect the Albert family to a degree that night by choosing not to follow protocol and call the DPW or the police about the Ford Edge parked on the street outside their property during a snow emergency. Brian Loughran confirmed that John O'Keefe was not on the front lawn at the Albert residence at 2:45 a.m. That means that Karen did not hit him. There was no collision. All the experts agree on that, including the Commonwealth's expert, and the only eyewitness that morning confirms it. Taking the evidence in the light most favorable to the Commonwealth at this juncture, with their evidence weakened by an airtight defense to these charges, these indictments cannot stand, and we urge this court to enter required findings of not guilty on all 3 indictments.
All right, thank you. Come on.
Thank you, Your Honor. Commonwealth.
Ooh, Lally. Interesting. Lally's making this response. Has Brennan lost his mojo? Has Brennan lost his mojo? Did he have a crisis of conscience? What are we doing here? Okay, Lally. All right, what you got?
Request that the defendant's motion for required finding not guilty at this juncture, as it was at the close of the Commonwealth's case, be denied. The state of the evidence is not dramatically changed since the Commonwealth rested its case in chief. Counsel makes reference to dog or canine. I would remind the court that there is absolutely no evidence, none, not even a scintilla of evidence of a dog.
Scintilla.
There's no evidence of an absence of a dog. You have Ms. McCabe testifying that she didn't see it in the morning, which does not equate to there being an absence of a dog there.
Well, it's some evidence. The
Arguments
dog
from
isn't there,
counsel
to be
of
honest.
Commonwealth would suggest grossly exaggerate.
That is a scintilla that the dog is not there. A scintilla is anything. The fact that she didn't see the dog is some evidence the dog is not there. It doesn't mean the dog wasn't there, but it is some evidence of it. By definition. Do you know what evidence is? Evidence and relevant evidence by definition is anything that makes it more or less likely. That's what makes it relevant evidence. So if she didn't see a dog, that makes it less likely there is a dog. So that makes it relevant evidence. So that makes it a scintilla. What are we talking about? I'm confused.
The strength of the defense witnesses in their case, the bias and advocacy exhibited by those witnesses from that witness stand do not amount to credible witness testimony that undermine the Commonwealth's case in any way, shape, or form. Couple of specific examples. When it came to Officer Barros, his testimony was also that the cruiser camera footage from 8:22 in the morning at the driveway at One Meadows Ave, he indicated the damage to the taillight was consistent with the damage that he observed in the driveway at the defendant's parents' home, which was then consistent from the video or the photographs within the Sally Port. It's also consistent with 5:07 a.m. at One Meadows Ave on the still frame shots from that ring camera video. Essentially, the Commonwealth would submit that the defense witnesses all conflict with each other. You have a couple witnesses testifying about dog or animal bites. Then you have the ARCA witnesses testifying about superficial abrasions. You have Dr. La Posada talking about the drop in body temperature, which conflicts with Mr. Loughran's testimony as far as his confusion, as far as the hours of when he sees or claims to have driven by there and not seen a body. This is the same witness who is, I would submit, very confused on times, and then also backed into a basketball hoop during the course of his plow duties on that particular early morning as well. And as the court could see from the cruiser camera video, drove by the scene countless times, essentially rubbernecking it as he's going past doing his duties. Your Honor, what the Commonwealth would submit is that his case was more than sufficiently strong at the close of the evidence in his case in chief. There has been nothing presented in the defendant's case to diminish, particularly to the standard in the light most favorable to the Commonwealth, and we request that the defendant's motion be denied.
Yep. Motion denied.
Mr. Yannetti, you know I have to view this in the light most favorable to the Commonwealth.
I do, Your Honor.
And viewing it that way, the Commonwealth has met its burden, so the motion's denied.
Thank you, Your Honor.
Okay?
Yep. She's right.
Right.
She is
So
right.
regarding the
A lot of bullshit, but that
charge-
one's right. All right.
So we'll start with the defendant's missing witness request. Who's arguing that motion?
We're not arguing that, Your Honor. And I apologize, but we made the decision last night to withdraw 2 of our requested instructions, which would shorten things today, I think.
Oh, okay, so everything on this is done, right? The defendant's motion to present a missing witness argument and request for instruction, you're withdrawing that?
With regard to the absent witness instruction, we're withdrawing that request.
Okay.
Withdrawing it for an absent witness request. Why? Yeah, I'm working on that. I'm going to sit here and ponder for a second and see if I can figure this one out. I got nothing. Anyone chat? The missing witness is Proctor. Yeah, the missing witness is Proctor. It's an adverse inference instruction. Basically says in so many words, the Commonwealth had the ability to produce Proctor. It didn't. You, the jury, may conclude that the witness would have been harmful to the Commonwealth's case. Essentially, in so many words. Yeah. Anyone have? Yeah. Bama law or MG law? Do you got any ideas? Yeah. MG law. Why'd you wall that? The fact the Commonwealth didn't call the lead investigator is a big deal. Yeah, that's what I'm trying to figure out. Yeah. Why would you do that? Yeah, why would you abandon it? I don't get it. The defense could have called Proctor. I understand. But notwithstanding the fact that they could have called Proctor, at least in Massachusetts, you can get the instruction. It's possible in Massachusetts, which, is not necessarily true in every state, but in Massachusetts it is possible, which is something, incidentally, I learned through this trial because I was under the impression you couldn't do it anywhere, but in Massachusetts you can. So, hey, we all learn something about law every day. Who knew? They're somehow tainted? Dude, the defense is tainted? I don't think that's it. It'll hurt the defense more than it'll help? Really? The missing witness instruction would hurt the defense? You think so? She just deny it? Well, be that as it may, I don't understand why they're not making it. Whether she denied it or not, I don't understand why they're not making it. Just because she denies it doesn't mean you don't make the motion. That's not how that works at all. Okay, well, let's go back to the hearing and we'll see if we can figure it out along the way.
And what else from your proposed instructions? You said there were two. What's the second one?
The second one is that there's an entry on our request for lost or destroyed evidence where we're withdrawing that.
Okay, I had a question about that. All right, thank you.
There is a supplemental instruction that we're asking the court to give regarding the display of the sweatshirt.
Oh, that's right. You filed, I saw it in email. I don't have a hard copy of it.
That's Mr. Alessi's.
Your Honor, if it's helpful to Your Honor, I'll hand up my hard copy.
Okay, if you could do that, I'd like to go back through the rest of it and
You'd
come
have
back
called
to that
Proctor?
after I've read it.
I understand
okay?
them not calling
Who's
Proctor, that I
arguing
understand.
for the rest
Or
of
at
the
least I've
defendant's
come to
proposed
understand it.
instructions?
I am, Your Honor.
Okay, so we're going to go through them one at a time. Who's arguing for the Commonwealth? Okay, so I think you're sort of in agreement on the basis of the law, right?
Yes.
All right, so model homicide instructions, just as last time. So that takes a lot of time out of today.
Your Honor, the only thing I would draw the court's attention, the Commonwealth does have a request for, and I understand what the court's position might be on this, but as far as the instruction related to murder charge, Commonwealth is only seeking an instruction on third prong.
All right, so we will deal with that. I'm going to go through the defendant's instructions, or sort of the general instructions first, so it's probably easier to go through those, and then we'll have the argument on that. So presumption of innocence, I think my presumption of innocence is a little more robust than what you've requested, so I will probably, okay. And I will give some version. I know that there was a lot of attention paid and some appellate decisions on the each individual indictment. I'll give some further language on that. You've got an instruction proposed on page 4, reaching a verdict. Just, I will make it crystal clear, though I think it was, and I was upheld on it, so I will make it crystal clear, okay? So I'll give you that, Ms. Giannetti. This what is evidence. I probably won't give verbatim what you have. I'll take a look at it, but I will certainly cover all these topics. So, Ms. Giannetti, you're telling me that your client wants me to give a defendant did not testify instruction?
Yes, please, Your Honor.
Again, if you want to take a look at what I gave last year, I think it's a little more robust than this.
I think we answered satisfied with the court's instructions on that, so we would be satisfied again with the court's language.
Okay. Humane practice, I will give you Bowden. I'm going to take a look, size this up with what I gave last year. I gave Bowden last year. I gave a Bowden instruction. I don't think the Commonwealth objects, right?
We would object to the instruction.
Okay. Go ahead. Do you want to make an argument?
Just briefly, Your Honor, when it comes to the Bowden, and I would incorporate, and I know there's no request for instruction from third-party culprit, but the Commonwealth would be making a similar request that counsel be prohibited from making a third-party culprit or Bowden argument.
Or Bowden? Or Bowden?
I'm sorry?
You don't think the Commonwealth, the defense should be allowed to make a Bowden to argue Bowden?
So I would submit, Your Honor, that the entirety of any testimony or evidence related to either Bowden or third-party culprit in this trial has come from questions from the defense counsel, not from actual evidence in the case, not from testimony from witnesses from the stand, exhibits that have been put into evidence, or anything of the like. So in the instruction and the arguments are based or predicated in the case law on evidence, not, and obviously, as the court is well aware, there's a specific instruction that no matter how powerful they are, questions of counsel are not evidence. So what the Commonwealth would submit is if the court looks at what is actually in evidence in this case, there is no basis whatsoever for not only a Bowden or a third-party instruction, but specifically for even counsel to make that argument during the course of the closing. And I understand Bowden is a little bit more loose as far as the court certainly.
So I'm going to ask Ms. Giannetti to explain to me. All right, so I disagree with you on Bowden, but I'll take a closer look at it. Ms. Giannetti, what is the Bowden evidence that warrants an instruction?
I think it's multifaceted, Your Honor. The police did not secure the crime scene properly. They used inadequate material to pack the evidence. Chain of custody was contaminated and corrupted. There was evidence of the bias of the lead investigator, failure to pursue other suspects, specifically telling his friends that the homeowner was sacrosanct because he's a Boston cop too. There was just a focus on Ms. Reed to the exclusion of everybody else. It was not an open-ended investigation. From day one, it was focused on one person and one person only. And just responding briefly to Mr. Lowry's comments about how he didn't introduce affirmative evidence of the proper way to do an investigation. We tried, Your Honor, we made a motion and renewed it, asking for reconsideration of the court's ruling that Mike Easter could not testify about an investigation. So to say that we didn't introduce that evidence when we tried to do it, we were forgetting.
I think what Mr. Lally was saying, that you asked questions but weren't given answers. And so I think that's what was said. I'm going to, Mr. Yannetti, I'm going to allow you to argue Bowden, and I am going to give an instruction. So third-party culprit's an entirely different animal here. I know, but tell me, are you going to argue it? Is the defense going to argue that Brian Higgins did this?
No, we're going to argue that the police failed to investigate whether Brian Higgins did it.
Okay, so just so that it's clear, you all know, I believe, third-party culprit separately is a lot different than third-party culprit as it goes to Bowden. I ruled pre-trial that there could be no attempt at introducing third-party culprit evidence regarding Colin Albert. So that was separate. But I did say that I would give you the opportunity to try and develop testimony regarding Brian Higgins and Brian Albert as third-party culprits. That threshold that you need to make to do that, to argue them as three-party culprits, has not been made by the defense. So you cannot argue that either Brian Higgins or Brian Albert
I tend to agree.
committed or had the motive and all of that. Not third-party culprit, pure third-party culprit. You understand that? It sounds like you're telling me you don't intend to do that.
We understand the distinction, Your Honor, and
Yep.
we're strictly going with a Bowden defense.
Okay, so
Yep.
you can get into third-party culprit with Brian Higgins, that the police were aware of whatever you're going to argue and failed to act on it. But it's strictly for that purpose, okay?
Yeah, I think that's roughly right here. So we got two separate issues that they're discussing, right? The failure of the investigation and that so-and-so actually did it. The failure to investigate that someone did it and that someone did it are not the same thing. And I think the ruling here is probably correct. Like the evidence relating to the police investigations and failure there too is paramount. So we don't need to spend any time talking about that. With respect to third-party culprit, you need a prima facie case to be able to argue a third-party culprit, and that's just not really developed. You have at best some motive relating to that, and also motive, of course, is not an element of the crime anyway. So you don't really have the elements to show a prima facie case for anybody. So you can't really say Brian Higgins did it or anyone else really did it because that evidence has not been developed. She wouldn't even allow evidence relating to Colin Albert to be developed, which is a whole nother set of problems, but which is an issue unto itself. But in any event, the evidence has not been developed for a third-party culprit. So I tend to agree with her rulings. It is the prima facie case is not been made. So I think that's correct. Let's listen to some more.
Okay.
And that's really what I was seeking, was clarification based on
Yeah. So Ms. Gianetti, and of course I take him at his word, tells me that they're not going to do pure third-party culprit. Okay, that's great. That makes that easier. So I will give, sure, go ahead.
While we're on page 8, I just wanted to, Commonwealth does have an objection to the DG instruction.
You never thought you'd hear Kurt say, I agree with her rulings? Then you have not been paying attention to this channel for any length of time. There have been multiple rulings with the judge that I've agreed with. I agreed with her not giving the directed verdict just now. I agreed with her not giving the directed verdict at the start of the case. I obviously agreed on the double jeopardy issue. There have been many rulings, the judge, that I've agreed on. You've not been paying attention, I guess. I don't know what to tell you.
Yeah, I have a check mark next to that. Ms. Gianetti, tell me about this, the absence of a recording. Are you saying that the police should have recorded Ms. Reed at her parents' house?
You know, I agree with the rulings, not her rulings. Well, what's the difference? If it's a ruling she made, it is her ruling. What's the difference? I don't get it. There are a lot of rulings of hers I don't agree with. I don't think she's a particularly good judge. I think she's disaster fuel in many ways, but like sometimes she gets it right. So I don't know, man.
Right, so, obviously it's not the strongest DG Batista argument that we would have, does not occur at a police station, but, these days, Your Honor, it's common knowledge. Everybody has access to a recorder, even on your own cell phone. It could have been done, it wasn't done. We had to rely on police memory of what my client said or didn't say when there was a possibility for a recording, so we still think we're entitled to the.
Do you think it was custodial interrogation? Or I guess I should say, do you think the evidence supports?
I think there's an argument that it was a custodial interrogation. We had police officers who, refused to sit down in the living room. They were surrounding her. Someone who was not familiar with dealing with the police at all. So yes, I think there's an argument that it's considered custodial.
All right, what do you say about all this, Mr. Hill?
And I would also add, Your Honor,
Sure.
they did seize her vehicle around the same time. So, that it goes to, I think, the issue of custody and my client being able to not answer.
All right. What do you say?
That's the very nature of the objection, Your Honor, is the non-custodial nature of this. So the trooper spoke to Ms. Reed at her parents' house, as they did with a number of different witnesses on that day as well, throughout the course of that day. They spoke to her while she was seated on the couch in her parents' living room. The parents were present, no one was restricted from meeting. And it did not end in any sort of custodial situation.
That doesn't sound custodial under the relevant law.
Yes, they did seize her cell phone and her vehicle based on information that they had developed from the course of the day and from the statements from Ms. Reed.
Yeah, that doesn't sound custodial under the relevant law.
And transforms that conversation
Yeah.
in her parents' living room into a custodial
Yeah.
interrogation.
Yeah, that doesn't sound
The
custodial.
other issue that I have is placement, as far as there's already been within the same requested jury instructions or requested humane practice, and then following the DAG and Batista language.
And I give a summary of each side's argument. I think I've been doing that already. Have I not been giving a summary of each side's argument when they make arguments, or a summary of the rulings at least? Right now, they're arguing over whether or not when the police interviewed Karen Reed in the apartment in the living room of her house, it's custodial. But it's probably not custodial. Miranda obviously applies anytime there's custodial interrogation. So obviously you need two things. You need the interrogation, which is they're asking you questions, and you need custody. And what is custody? Well, the short definition of custody is that a person of ordinary prudence would not feel free to leave. And that requires the police to essentially exercise dominion over you in some way. And that can get really complicated really fast. The police putting cuffs on you doesn't necessarily make a custodial. The police putting you in the back of a cruiser doesn't necessarily make a custodial. Yeah, this does not sound custodial under the relevant law. So yeah, that's my best opinion.
Defendants request jury instructions, there goes on to all of this other.
The part doesn't make sense. It makes sense. Which part doesn't make sense? You have to be more specific.
While if it were to be given by the court, should be given in the same context of the main practice. I don't think it's something that should be highlighted in two different sections. And I would submit that there is no evidence of her having a compromised mental state.
They were seizing the car. How could she leave? By walking out the door. She was in her own home. She could have gone to a different room. She could have walked out the door. She could have told them to leave. Yeah, no problem.
Anything to that effect. She exercised her judgment as far as when she was speaking with Sergeant Lieutenant and have his testimony from the stand, that initially she said she wanted to be fine with answering questions.
They didn't have a warrant. They didn't need one.
And then when the questions became centered on, more centered on details, at that point, and I know that's not evidence before the jury, but of course, well aware, she then ended the questioning at that point.
Can the audio be turned up? It's already at 300%. If I turn it up much more, it's going to blow out the noise levels.
And I don't think that it rises to the level of a decent instruction. So I would ask basically that everything on page 8 prior to
$5 from Texas. Katie did. They interviewed her parents' host. They didn't have to record her Mirandize. Well, it's not quite that clean either. It's not that clean. It is possible that it could be custodial, despite the fact it was at her house. We've seen cases like that too, so it's not that clean. But yeah, Proctor was already targeting her. It may be legal, but it's unethical. Yeah, but we're here for law, not ethics. So yeah, moving on. Thank you. Why didn't they need a warrant? They let him in. They let him in the house. That's why. Consent. Easy. Next question.
All right. I'll take another look at this and I'll just let you know in the morning.
And Your Honor, with regard to the compromised mental state, we agree that that would not apply to the interview at her residence. But we believe that it applies within the humane practice context.
That is where it makes sense. So, all right.
if it's going to happen, it should happen once, not.
Yeah.
I would rule it's not custodial
Okay. Okay.
based on the information presented.
All right.
There's not enough indicia to
Prior
make it custodial,
statements, I will give some
in my view.
instruction on prior inconsistent, and I'll give a prior consistent statement. I will talk about the view. The absent witness instruction is withdrawn.
Custodial actually takes a fair amount more than most people, I think, give credit for it to be custodial. Because, like, as I say, like, the mere fact they put you in cuffs is not necessarily custodial. The mere fact they put you in the back of the cruiser is not necessarily custodial. You know, the mere fact they put you in the interrogation room is not necessarily custodial. It actually takes a little bit more for it to be custodial than I think most people give credit for. Custodial is a little bit harder of a trigger than, it's not like incredibly hard. It's not like insanely hard, but it's I think it's more difficult than the general understanding of it is. Yeah.
On, so is the,
Not to interrupt.
That's okay. That's okay.
With regard to the view, Your Honor, we did.
What does it take? It's not that easy to say, what does it take? It's not that clean. Yeah, see, this is the problem. It's not that clean. It's not like I can point you to anything. Like, every case that really discusses it basically talks about it as a multi-factor, right? It's a sort of a multi-factor test. It's not really clean. The cleanest definition I can give you is that custody is when a person would not feel free to leave, but then, like, if you're in cuffs in the back of the cruiser, how do you feel free to leave? Yeah. So yeah, the clean definition doesn't really work either. But that's the cleanest definition I can give you. is that if a reasonably prudent person would not feel free to leave, that's as clean as it's going to get. Yeah. Anything more than that, it's going to get complicated real fast.
Included language reinforcing the fact that the rock that they saw on the view
Oh.
was not.
Custodial is vibes, kind of a little bit, yes. Kind of a little bit, yes, it's
Okay,
vibes.
so I did not
Yeah.
see this when I took a quick look at the view. All right, I'm not going to repeat it.
What's the example of a case where custodial
All right,
applied?
lost or destroyed evidence, you're withdrawing.
What's a case where custodial applied? Basically, every time the police, when the police bring you into when the police haul your ass into the interrogation room, that's pretty much custodial. So yeah, that'll do it. If the police bring you themselves, like in handcuffs, into the interrogation room, yeah, that's probably custodial at that point. That'll do it. There you go. Yeah, that'll do it. That's a good one.
Direct and indirect evidence. I'm going to try and give a shorter instruction on that. So I will, even the one I gave is too long. I'm trying to cut down the time the jury needs to hear general instructions that I think they're perfectly capable of hearing in a shorter period of time. All right, thank you. Credibility, the same. Law enforcement witness, I think I gave some instruction on that. I'll include that somewhere in it.
If I might just in reference to that.
Sure.
Only language in there that I would object to.
Okay.
Testimony of a police officer or someone else who works for a law enforcement agency.
What do you mean by that?
I think that was taken into account for the dispatcher, perhaps. We're not.
Yeah, I'll do police officer because they're police testimony. I'm not going to go beyond that.
I think that language comes.
Okay, thank you. I'll do the photographs, the opinion testimony, notes. I'm not saying I'm giving exactly this, but I will give, I'll cover all those topics.
If I might just, as far as the photographs,
What page you on?
16.
Okay.
One suggestion there was indicates, now the Commonwealth has introduced photographs and evidence. I would submit.
Yeah, I'm just going to say there are photographs that are in evidence. Was that the nature of your objection?
I actually think the defense has introduced more graphic.
Yeah, so I would just say you've seen photographs.
Fine with that.
Or there were photographs and evidence. I instructed twice anyway, maybe 3 times on it, so I'll give some version of that. Juror notes, I'll give some version. The implicit bias instruction, I'm going to give exactly what the SJC told me I should give.
That's a good idea.
So the Commonwealth's requests are sort of in the, you start with the law and then you get into the general instructions, Mr. Lally. So let's skip to it's not numbered, your supplemental instructions, use of a dangerous weapon. All right, so I'm going to give that, Ms. Gianetti. I gave a dangerous weapon instruction last year on the motor vehicle.
Understood.
All right, so I'll give probably what I gave last year, and this looks like it's it. What is not evidence, evaluating, I'm going to give what is not evidence. Evaluating the evidence, there's some instruction. Ms. Gianetti, what do you think about the short instruction on jurors? It sort of makes sense to me after such a long trial. No juror is better qualified to determine the truth of the facts in controversy or to deliberate upon a verdict than any other juror, or solely because of that, solely because of that juror's occupation, education, experience, or any other characteristic. Okay. Thank you. Charts and summaries, I'll talk a little bit about chalks.
Chalk.
And inferences, I will give some. I'll give the redacted exhibits instruction. Witness preparation for trial. Do you both want this? There was testimony on both sides. It's simply, there was testimony at trial that the attorneys, and I may say if you find, or something, preface it. Witnesses when, the attorneys interviewed witnesses when preparing for and during the course of the trial.
No objection.
You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the attorneys are obligated to prepare their case as thoroughly as possible and may interview witnesses. I don't know if there's a sequestration order, if this is appropriate, though, where it says during trial, during the course of the trial. I'll just say when preparing for trial.
Fair enough.
We're joining in the request. I don't know that we included that in our instructions, but we're joining in the Commonwealth's request for that instruction.
All right.
The jury is not going to understand the difference anyway. It's fine.
Okay. Expert witnesses, electronic communication. So I'm going to go through the limiting instructions I gave. I need to just do this again here. So electronic communications, I have that on my list. The emotional
There is no
impact
rebuttal.
photos.
Just we're doing
Humane practice.
instructions at the moment.
We'll get back to consciousness of guilt in a minute. I'm also going to give the prior bad acts instruction. I did that in regard to the Aruba incident, if you want to call it
Aruba,
that. I gave a prior bad acts
I'm
instruction
gonna take
before
it.
that testimony came in. I also gave the instruction that I will also give on the state of mind of John O'Keefe as to his state of mind being known by the defendant and the likelihood that she would act on it. So Commonwealth versus Binns in those cases.
Your Honor, with regard to Aruba, we don't believe that there was really any guilty that came in.
Yeah, there really
I thought
wasn't.
it came in through Kaylee. I should say it did come in through Kaylee. That's when I gave the prior bad acts instruction. She testified.
They certainly didn't spend a lot of time on it.
Okay.
There weren't the
All right,
8,000
so
witnesses about Aruba.
Did I give it any
Did they
other
mention
time
Aruba?
that there's another event that I should highlight? I don't think so.
Gave an contemporaneous instruction regarding the text of the misdemeanors. May have.
I don't think there was an instruction at that point.
All right. I think I have to add that here. So, all right. And I will look at it and decide whether I need to add it specifically. It might be covered enough. Might be covered enough when I give the electronic communications instruction. So I will think about that. All right, those were the limiting instructions I wanted to get to. So,
We would object to the prior bad acts being linked to the Higgins text message.
all right, I'm going to take a look at that, Mr. Lessie. All right, consciousness of guilt.
Your Honor, Commonwealth.
Okay, all right.
Good. Yeah, they good win for the defense and probably a smart move by the Commonwealth because there really isn't anything that displays consciousness of guilt here. Or, yeah, so they withdraw the consciousness of guilt instruction. Good one for the defense. Nice win.
All right, so tell me where the difference is in what I gave last year from the model homicide instruction on second-degree murder and where you're saying I should not this year, Mr. Lally.
Your Honor, so the only,
1 second, let me just pull that up. Okay,
Your Honor, Commonwealth's request is merely not for any change or alteration in the instructions that were given other than there are 3 prongs of malice. Essentially, what Commonwealth is requesting is that the jury be instructed
speak up.
merely on 3rd prong malice, as that's the only one that really applies to these facts and circumstances.
Okay,
The Commonwealth here, the first 2 prongs are essentially strangers in this situation and don't need to see explanation of the jury. To avoid confusion.
do you have supportive case law for me to single this out?
I do.
What do you say, Ms. Giannetti?
I mean, Mr. Brennan essentially stated that in his opening statement.
Stated what?
Well, in his opening statement, he stated that he's not alleging that she intended to do him grievous bodily harm. She did not intend to kill him. And it was just the third prong. He stated that in his opening. I imagine that's what he'll likely argue in his closing. You know, I don't have a position on this. I just don't know, and I think the court's going through this analysis in your head as well, whether it's permissible or not. I just raised that as an issue, but I don't have strong feelings about it.
I could say the parties agree that the first prong and the second prong are not applicable here.
I think we're just at the position where we'll defer to the court on this.
Well, I'm not going to say you agree if there's no agreement. If you can get me a case by this afternoon,
I will endeavor to do so, Your Honor. We will. I don't have anything.
I'm inclined to go with the model.
Yeah, nothing wrong with the model instructions. That's why they're there, baby. You'd be hard pressed to get reversed on the model instruction. You know what I mean?
I'll see if there's something I can find. You're probably better at finding it than I am, Mr. Lally, but I'll see if there's something I can find to support the position that it's just the third prong, and therefore I only have to give that instruction. I don't think I'll find anything, but let me see. Because I can understand why both of you don't want it. Just let the jury focus on what they need to focus on.
That's really the only reason for this. But I understand, and I don't certainly want to take.
You know, I suppose I could always tell the jurors that the Supreme Judicial Court has come out with jury instructions that I must give in their entire format. And that sort of explains why I say something that doesn't apply, maybe.
We wouldn't have an objection to that.
Maybe I'll do that, but let me see if I can find something. If I can find something that says I don't have to give those first two prongs, I'll let you know before you begin. All right.
And Your Honor, before the court makes a decision on that, could we see what the court is proposing if you are going to alter the model?
If I alter it, it means I remove those two. That's all.
Right, no, we just wanted to.
Yeah, sure. My guess is that won't happen, but we can see. All right. So, lesser included offenses. Did you want to know UI instruction? You were.
We're asking for that.
Okay. All right. Right, I think that's it, aside from Mr. Alessi's motion regarding the exhibit.
Are we
Right,
seriously
is there
not going to
anything else
ask
that's
about?
that we're missing?
Are we seriously not going to ask about the partial versus complete verdict thing? Seriously?
Proctor text messages, we have a redacted version.
How is that not question number one?
Submit to the court of the Commonwealth. You recall that we had agreed essentially on a redaction subject to the court's ruling.
Okay,
But it wasn't in final form. We believe it's in final form now.
and you all agree that it's in final form?
Well, they haven't seen it.
Oh,
But I'm going to
okay.
give it to them now. Can I hand this to the court?
Sure, thank you. All right, so,
The only other issue, Your Honor, is we do have a...
hold on one second on this issue still. So I will give the Commonwealth this afternoon to take a look at this. And tomorrow morning, if you don't have agreement, then we'll have to deal with it, and I'd prefer not to have to deal with it, so,
I'm sure we can be in touch this afternoon. I do not believe there's going to be any problem.
okay.
Just a couple other things before we get to Mr. Alessi.
Yeah.
One is that we do have the Dr. Wolf PowerPoint to be introduced to the evidence, Ron.
Dr. Wolf or Dr. Rentschler?
Dr. Wolf.
All right, and this was allowed into evidence unobjected to. I thought we already had it, we didn't?
We have to redact it, so we
Okay.
redacted. It's on a thumb drive.
Okay, and the Commonwealth has seen it? All right, so they'll have to see it. So Mr. Lally, Mr. Brennan, Ms. McLaughlin, one of you has to take a look at it.
And then, will the court allow?
I mean, unless it's already in the draft instructions and they've agreed and there's like, although even then as a judge, I'd make a note of it on the record because of how important it is. So the fact that she's not mentioning it is kind of blowing my mind. What do you mean you're not mentioning?
Within an hour?
I'll allow more than an hour. I'll allow an hour and 15 minutes.
Thank you.
All right.
And I think I did mention that we had a proposed verdict slip for count 2, Your Honor, if I didn't.
You did not.
Okay, we do have one, we've got given a copy to the Commonwealth.
I bet you do have a proposed verdict slip for count 2.
Sure.
I bet you
Is
do.
it the same as last year's, but now with a?
It's different.
No, they have new improvements since last year. Exciting.
Okay. All right.
You'll have a chance to digest that.
Oh, I digested it, Mr. Alessi. Go ahead, I'll hear you.
I'm actually Yannetti.
Yannetti, jeez, I'm sorry.
So, Your Honor, you'll recall, we had some spirited argument both before and after trial regarding this particular issue. And our concern, Your Honor, was that it's obviously a confusing indictment because of the number of lesser includeds and the number of elements that are different for each lesser included. And we were uncomfortable with, there being one option for not guilty at the top of the form, and then multiple options for multiple different types of guilty verdicts throughout the remainder of the form. So what we have done is to fashion this in a way where the jury, pursuant to the court's instructions, would first decide the offense as charged, and if it's a guilty verdict,
Madam Clerk?
the analysis is over. If it's a not guilty verdict, they go on to the next lesser included offense, and again, same analysis applies. If it's not guilty, they then go to the next.
Okay, that makes a little bit more sense.
Finally reach the final verdict, which the lessest, or the least.
So they want a not
sensitive
guilty paired with
of the
each one
lesser included
separately.
offenses is simple
And they want
operating
some sort of flow
related
instruction.
option for not
That'd
guilty.
definitely be cleaner.
We've also changed a little bit of the wording, you'll see, which I think makes it clearer and less confusing. When the jury is given options for theories of guilt on at least, it's like three of the charges, including the main charge, because there's this issue of either under the influence or 0.08 or greater. The way it originally read, Your Honor, manslaughter while operating a motor vehicle under the influence of alcohol was repeated twice. It was repeated once where there's an option for guilty, and then it was repeated again with both of the other options. We think that this is simpler, it's cleaner, it's clearer, and we believe that this verdict slip is the most appropriate one.
Mr. Lally?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly understand that if the evidence supports it.
I'm sorry, what?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any lesser included, and I certainly.
Are you now or not requesting? What is that word?
Your Honor, as the court is probably well aware, the Commonwealth is not requesting any
I can't tell.
lesser included, and I certainly understand that if the evidence supports it, the defense requests it.
Oh, the prosecution isn't requesting lesser includeds. Interesting. Interesting. The prosecution's not requesting lesser includeds. The defense wants lesser includeds? Okay, pressing on. All right.
Having said that, the verdict slip that was used in this matter last year, the Commonwealth Smith is more than sufficient and adapted to the defendant's request. The only other thing I would bring to the court's attention, I don't know if you're aware, there was a case recently, while this case was going on, tried before Judge O'Keefe, in which he had similar issues. And I believe use at least part of the verdict slip from the first trial, in this case, as sort of a template for the lesser included that he instructed and the verdict slip that they utilized in that case. I don't have a copy of it on me, but I can certainly get the court a copy with it. Looking at some copy of the docket, but that may be somewhat helpful if the court is thinking of
Okay, was that on murder case?
It was not, but it had to do with a felony motor vehicle homicide.
Yeah, I'll take a look at it.
Mr. Turk. Mr. Turk.
Mr. Yannetti, I don't believe I'm going to give this, but I'll take a closer look at it.
Well, we appreciate that. Judge Well is an excellent judge. We think that this verdict slip is, it provides the most clarity for the jury. That's why we're.
Okay, and that's where I think we disagree. So I will take a closer look at that. And so has it been filed officially and docketed?
I just handed it, I believe.
All right, so Madam Clerk, you have a copy up there?
The proposed, I think this is the only copy.
Okay, that's what I was wondering, okay.
Do you need an extra copy?
The defense wants lesser included. Really?
Sure. Yes. Or, you know what, just mark it for identification, Margaret. We'll do that. Chrissy, please. Just for ID.
It's LL for ID.
If Bev includes lesser included, but if the prosecution doesn't want lesser and the defense doesn't want lesser, I don't think the judge can just include lessers on her own. I don't think she can do that sua sponte. So it doesn't make any sense. The prosecution doesn't want lesser includes. If the defense doesn't want lesser includes, I don't think the judge can do it. So the only reason to present the verdict form is that they themselves want it. Right? Yeah. So, yeah, that doesn't make sense. So why does the defense want lesser includeds? I don't understand. I don't get it. I don't understand.
Thank you. Mr. Lally.
Your Honor, just one request circling back to the constitutional instructions. So the Commonwealth is withdrawing its request for the instruction.
Okay.
However,
No, nothing makes, I don't understand.
make some argument or reference in its arguments to the jury related.
The only thing that makes sense is, oh God, and I don't even think it makes sense, to be honest. The only thing that makes sense is that they are so paranoid that the jury wants to find guilty on something that they want to present options to give them the least something to find guilty on, so that if she's convicted, she serves the least amount of time. But that sounds like a batshit crazy. That sounds like something a defense lawyer would not do. That doesn't sound like something a defense lawyer would do. I don't get it. I don't understand.
To specific areas which we would need judicial approval before we did. So the two areas that are sort of listed within that we would like to make some arguments to the jury regarding is the defendant's taking of the Lexus from when Metal Dab came to her parents' residence indictment, and then certain statements made in reference from the various clips that were played of her statements.
Okay.
In particular, would be the one where essentially she says
I don't get it. I don't understand.
Okay.
I need a lawyer to explain it to me. I need a
All right.
lawyer to explain to me how it makes
Mr. Netti,
sense.
do you want to weigh in on that?
Yes, quickly object to that. I don't see it's her or me being evidence of consciousness of guilt. And the notion that she's driving from one residence that the police know of to another.
That's for the
residence
manslaughter
that the
charge.
police know of, which is her parents' house. The car is open and obvious in the driveway. In fact, when the police call, she says, yes, come on over. I don't see that as being any evidence of consciousness of guilt.
Okay, so I'm going to allow them because they're permissible inferences from what's in evidence, but I'm not going to give, even before it was withdrawn, I wasn't going to give a consciousness of guilt on those.
Hey, mods, can we see if we can, like,
Yes, so I
get a
did want to
collab
ask
going
you,
with
though,
one-
Mr.
We're gonna
Yannetti,
do
I think
Larry
it's an
we're gonna
argument
do
that can
Larry
certainly
tonight
be
at
made
4.
by the Commonwealth
Can we
regarding
see if we can do a collab or something with
video
somebody or
clips that
stream
your
with somebody?
client
'Cause this
gave
is-
during various
I need someone to
interviews.
explain
I
this
think
to me.
consciousness of guilt is a permissible inference from some of those. Are you sure you don't want me to give the consciousness of guilt because it's got helpful language for a defendant in it as well?
No, we
Okay.
do not like it.
Okay, I just wanted to give you the opportunity. Okay. All right, anything else? Anything else, Mr. Yannetti? We're going to hear from Mr. Alessi, but
The Commonwealth does not object to the redactions of the
that's great. Thank you. One less thing you all have to do today, okay?
This is Mr. Alessi.
I know. All right, so let's make that, are we switching that new redacted version with the exhibit number? Do we know what it was before? Excuse me.
You can explain it? Well, fine. Then I'll send the link to my mods and you can hop on and explain it because I don't understand it. Yeah, if Larry can jump on now, that'd also be great. If he's available, I'll take it.
The redactions on the Higgins messages, that's what you're saying you're fine with, right?
Proctor Communications.
Proctor Communications, okay.
But this is the testimony that came in.
Of Proctor, yes. All right, so we'll find the exhibit number and we'll just... 209, is everybody in agreement that it's exhibit 209?
Yes, sir.
Okay.
Does the court have a copy or do they need a Commonwealth?
No, I wrote on it. I need the Commonwealths.
So this is a clean copy. This one.
So that will now be 209 in evidence. You know what, can we make that 209A? We need, Mr. Yannetti, we need to keep record of the first one that was not redacted, so any objection to making this 209A?
No objection to that. And so original 209 will not be sent in. Is that?
It becomes.
What do you think? Yeah. Yeah, so we'll switch it back to ID, and this will just be 209? All right, did we have an ID number on it originally? Can it still be that?
Is it redacted the NNN? Or is it, no, it can say that.
Okay.
Right, 'cause this is the-
Oh, it's just NNN, it's not,
Well, where did it?
no, it became 209.
So there
Our
has to
thinking is it needs to be sent back to letters for ID.
Yeah.
So it'll be marked MMMM for ID.
That's great.
Perfect. And then the redacted version will now just. become
209,
209.
yep.
Travis, are you on Twitter or are you on, where are you? So I can send you a link.
And we'll hear from you this afternoon. Just somebody send us an email to the clerk's office. So someone send an email to the clerk's office today letting us know if the Wolf PowerPoint is ready to be put into evidence after the Commonwealth looks at it. Okay, so we'll take care of that. All right, Mr. Alessi, I'll hear you.
Thank you, Your Honor. If I might suggest respectfully a procedure to the court, I have spoken with the Commonwealth about what the topic is. It's obviously not new to anyone, but perhaps to expedite this matter, if I might.
All right, send Travis a
suggest,
link,
Your
see if he wants to jump
avoid,
on this.
A more lengthier argument, it might even truncate it down to 30 seconds. If we could hear from the Commonwealth on what we have requested, and the topic specifically is entitled Defendant's Motion for Curative Instruction regarding Exhibit 88 in Introduction.
Are we seriously not going to ask? Are we seriously not going to ask about the partial versus complete verdict thing? Is no one going to bring it up? What the fuck? How is no one bringing it up after all that? Someone's got to explain that to me too.
Exhibits, the exhibits is taken care of, that's no longer an issue. But I did speak with Mr. Lally, and if I could suggest that Mr. Lally could state his position as I understand it, and then I can go from there, and it may not be necessary for me to continue on.
All right. What's the Commonwealth's position?
But Your Honor, the Commonwealth's position is ultimately I defer to the court as far as whether or not it's an appropriate instruction to give in the final charge. What the Commonwealth would submit is that the contemporaneous instruction was more than sufficient to address the issue, and that it doesn't require any sort of differing language or further instruction given to the jury during the court's final charge.
Okay. All right, I'll hear you, Mr.
Thank you, Your
Alessi.
Honor. May I go to the podium?
Yes.
Thank you. Your Honor, I have given, and Your Honor has provided me previously with a generous opportunity to be heard on this, but I do need to cover some points with regard to the matter. I was hoping to avoid doing this, but given what we just heard, it needs to be done respectfully. As Your Honor knows, we have submitted this motion, and as part of the motion, it really consists of two parts. The first part is the text and the basis for what we're requesting. I'll come to that in a moment. And then attached to it are is Exhibit A and Exhibit B, and those exhibits are our best effort at transcribing, because there's not an official transcript at this point of exactly what happened. Why do we put in the exhibits? We put in the exhibits because we believe it really sets forth and illuminates quite vividly what occurred. It occurred rather rapidly, but I think this allows for a much more these exhibits allow for a much more reflective analysis. So just briefly, what, as we know, happened is Attorney Brennan took Exhibit 88 encased in whatever the plexiglass material, had it set up, and we understand this now in retrospect, behind the witness stand. And then at a certain time in the cross-examination of our witness, Dr. Wolf, confronted Dr. Wolf with it as part of an accident reconstructionist cross-examination, and challenging Dr. Wolf on several aspects. And this one was particularly apt, the subject matter, not the manner of the examination, was, Dr. Wolf, you're saying this, these are your theories. However, did you consider and take into account the holes in the back of the hoodie? And that led to a series of questions and a series of answers. And I want to go right to the end, because I think going right to the end better elucidates what actually occurred and the depth of the issue and the problem here in this misconduct, which we believe was intentional. Specifically, the end is, we know, and I believe it is completely undisputed, that the holes in each and every hole in the back of the hoodie was caused by the criminalist, a witness in this case, Ms. Hartnett, who made those cuts as part of her analysis, and that was in May of 2023, long after the alleged incident of January 29, 2022. So that's sort of the end undisputed. Now let's go back to what happened in the examination, the cross-examination of Dr. Wolf. So he's confronted, and I think, we put in Exhibit A and B of it, but what is particularly striking is on page 7 of Exhibit A, and it's the colloquy that starts in the middle, which we've yellow highlighting, Attorney Brennan saying, when you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm? Dr. Wolf started to answer, well, I know that there was cutting to, and I emphasize cutting, and then he was cut off by Attorney Brennan, and Attorney Brennan said, may I approach and receive the exhibit, Your Honor? And we note that in the context of many other statements in this regard as to what happened. So now this comes to the requested relief, and I'm going to move to the part of the argument, Your Honor, that we believe respectfully compels what we're requesting. So now I want to just state what we request. We believe what we've requested is quite modest given what happened. And our proposed curative instruction is on page 2 of our motion. It states, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt, Exhibit 88, falsely insinuating that those holes were sustained on January 29, 2022 from a fall backwards. I instruct you that those holes were not present on January 29, 2022. Those holes were made by Maureen Hartnett, a criminalist at the Massachusetts State Police, I've got the acronym MSP, Crime Lab, in the course of her inspection and sampling of the clothing on May 18, 2023. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29, 2022. Please juxtapose that with regard to the instruction Your Honor had given, which was a sentence, so, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt.
Didn't I include the date you requested, the May 18th date? I thought I did.
You know, Your Honor, I think the answer is no, but because I'm doing it from memory and I don't...
This is not an official transcript, right?
Exactly, Your Honor, so I can't say it with certainty. I don't believe it was.
Okay, because that date you told me was important to you, right?
Among other factors, the date was important.
It's May 18th, right?
Yes, Your Honor.
Okay. Go ahead.
And so, Your Honor, I believe what is fair in the analysis and as objective as I can be here is, I think the curative instruction has to tether to and relate to in its details the degree of what happened. This was on a very significant topic, accident reconstruction, a significant piece of evidence, the hoodie. There's been much discussion among many expert witnesses about this hoodie, what it stands for. There's been videos on it. You know, our position, the hoodie in a proper accident reconstruction would be completely unaffected by any alleged motor vehicle incident. And then to show the witness on this for the defense, it clearly left the impression to any objective observer that Dr. Wolf had somehow been incompetent, which is 180 degrees of the reality, but also that he just wasn't otherwise diligent, and the jury, therefore, should not weigh and value his opinion. This is very, very significant, and I underscore, Your Honor, we didn't cause this problem. We didn't cause any of this issue. So, to me, I do not understand why the Commonwealth would not support this. What we have written down here supports the truth. We all, I believe, should have the common goal of the jury receiving the truth. I looked at the jury, I'm no soothsayer or mind reader, but I looked at the jury and they looked confused when I looked over at them, but I think even aside from looking at a jury, what Your Honor did in good faith, I don't believe is clear enough on this key issue, and I'm not understanding why there would be any real contest over making it clear to the jury on this very important point. The defense, to my point of being measured at the time and being measured now, we could be requesting a lot more statements about what occurred. And I've been in situations in other trials where things have happened and there's been many more significant things stated. So in conclusion, Your Honor, the defense not having contributed at all to this issue, the significance of the issue, the significance of the error, it's undisputed about the error, to me, respectfully, all augurs for more clarity here. And the final point, there's two issues here. There's the fact of when these holes occurred, these cuts, and how they occurred, that's one bucket. But the second bucket, which is not in the current instruction, is our expert witness, Dr. Wolf, and the impression left upon him. And that is why we have the language in there, again, we believe quite measured, just the sentence at the end to take care of the harm to our witness with regard to what occurred. So, therefore, Your Honor, we respectfully request that this be given so that the jury has a clear and complete and truthful understanding of not only what happened, but also to make sure that it is what's created for the jury is accuracy, hence truth can be concluded. Thank you, Your Honor.
Thank you. I do just want to point out one thing. It was not objected to at the time it came in. That's my only comment. I will consider this. I'm going to hear from Mr. Lally. I will consider it.
What is it that was not objected?
The testimony was not objected to. I didn't hear this until I think after another witness.
Your Honor, if I could just, thank you for raising
I
that.
missed the context
10
on
seconds
this.
for that. I will,
He's asking basically for a second cautionary instruction when the jury is charged relating to the whole snafu on the sweater, cuttings thing. That's what they're arguing about.
I mean, it was objected to. They had a lengthy argument on it.
Mm.
and I made this point the very time that I made the argument last time. We were not shown that Exhibit 88 in the encasement. It was behind the witness. We didn't even know that it was behind the witness. So what happened was Attorney Brennan went up, retrieved it, and immediately went to the witness with it, showed it. We couldn't even see what was happening. There was no physical nor other ability for us to object at the time. So I appreciate you giving me the opportunity to respond to that.
All right, Mr. Lally.
Just give the instruction.
Yeah, it's a pretty obvious instruction.
Yes, very briefly. I'm not going to get into a belabor the point as far as the back and forth about conduct of counsel. During the heat of trial, during the heat of the extended exchange with a witness on the stand, things can happen. Mistakes can be made. It was recognized,
Shit happens,
acknowledged,
stuff breaks,
and
massive injustices
accepted
and misleading
as a
of the jury.
mistake. There were numerous offers by the Commonwealth to offer a stipulation as to the truth as far as the evidence is concerned that were rejected by the defense. They wanted the curative instruction. They got it contemporaneous with when the evidence came in.
They got the world's shittiest
There have
curative.
been many,
Yeah,
many
one sentence
instances
long.
of
It was a little
similar type
little
conduct that
unsatisfying.
didn't result in a curative instruction, and to accentuate it further in the final charge to the jury is simply improper.
Yeah, shut up.
It was a situation that arose as far as whatever misstatement
Brendan
was
currently
made at the
working on his
time, as far as
resume.
whether it's from the testimony from the witness or the question from counsel, was immediately remedied, was taken care of. I don't think that there's any confusion by the jury, and furthermore, as I indicated, the Commonwealth offered a stipulation at the time that this occurred, which was essentially rejected by the defense. They got the curative instruction at the time. That is all that is required. It is more than sufficient.
Lally
and
reminding
it
us
doesn't
why
need to
he
be
sucks.
accentuated or addressed further in the final charge.
Okay. So I'll consider it, Mr. Alessi, okay?
Thank you, Your Honor.
All right. Anything else? Two things I'd like to talk about for scheduling. The jurors get here early. I'm going to ask if the court officers to call the jurors and ask them two things. To ask them if they can get here a little bit earlier so that we can all be in the courtroom at 8:45, ready to start. So
cares? You
things
want an
take
extra
a little
15
while
minutes? What the
generally.
fuck?
That will assure us the closing arguments will start right at 9, maybe a few minutes earlier. The goal
Oh, yeah, I
would
really
be
need those
to
15 minutes. That's critical,
hear
man.
arguments from both counsel and then take an early lunch break. I would ask that counsel plan on just a half an hour lunch break. I'd like, the point being, I want the jurors to start deliberating. I don't want to end the charge and send them home for the weekend. That's not fair after they've waited so long. So a short lunch, you're free to stay in the building, and court officers will help you with accommodations for that. But a short lunch, and then I'll come out and do the charge. And then at least, hopefully, there'll be some time for them to deliberate. I'm going to ask the court officers to call the jurors to see if they can stay as late as 5 o'clock or 5:30 tomorrow night. I just don't think it's fair after they've sat through so much of this trial with the various delays that we've had to not let them start deliberating.
I'm surprised she isn't even asking longer, like stay till 7 or
We
something.
have judges during the last trial, during the
Apparently
deliberations,
there's,
the court had asked
I've
us to be
heard rumor
5
that
minutes
there's
in the
a
courthouse.
contract that
My
says they have to
office is
leave.
about 10 minutes away.
I'm sure we can make accommodations for that. But at some point, we may have to talk about security issues. So a lot may depend on that.
Understood.
All right. Does the Commonwealth have any objection to that schedule?
No, Your Honor, none at all.
All right, so we'll see counsel in here no later than 8:30 tomorrow morning?
Sure.
We'll counsel here at 8:30. All right, thank you.
All rise for the court, please.
And no discussion on the complete versus partial verdict
There's
thing,
already one of
which
those.
amazes me. How's that a thing?
Goodbye.
She did have some mention of it. She noted she was upheld on appeal and that she would probably just do the same thing as she did last time. So,
I guess. I mean, I guess, but that seems odd to me. Well, anyway, so we have the instructions, and it appears the defense is the one asking for lesser includeds on count 2 for manslaughter. The Commonwealth doesn't want lesser includeds, they said. And it's the defense apparently asking for lesser includeds and providing a jury verdict form for that purpose, which struck me as somewhat amazing. So Travis, make it make sense. Travis? No? He's still working on it? Can't hear me? Lou? Travis? Lou? Lou?
I think
All
we
right.
may have some audio issues.
We have audio issues. All right. Well, Ian, why don't you tell me what you think about what's going on while we wait for Travis to figure out his audio issues?
I mean,
I'm
I
good.
don't know. There's
Go ahead.
Oh, there we go.
There we go. No, I was like, yeah, can you please make it make sense why the defense is asking for partial verdicts at this time? Because that doesn't really make sense to me.
If that's to me, so, you know, it's a Hobson's choice when do you want it to be all or nothing, where let's do it on the murder, that there's just really no evidence of intentional, knowing that Karen Reed intentionally and knowingly backed her vehicle up in order to kill or cause serious bodily injury to Mr. O'Keefe. I think everybody would agree that there's just no way they're going to prove that. So you'd never want a lesser included on that if you're the defense, because it's not a tough choice. But if you want to get the manslaughter, which is 2 to 20, I think we figured out, and you think that there's enough there, sometimes you do want to offer them a split the baby thing back in the jury room. But I cannot fathom why you would want that on the manslaughter. Now, this is going from the original jury slip. Then there were the homicide, intoxicated homicide charges that they have in Massachusetts. It's called Melanie's Law, where it was tougher, much tougher penalties about 10 years ago because of a tragic accident that happened 2 counties over from Norfolk County. If you cause death and you're intoxicated, there was a lesser included on that last time. That's what I could see where the defense would want. But I really can't, Kurt, Runkle, maybe you know, I really can't fathom, given the evidence that's come in, the way it's come in, unless, you know, that juror consultant, that former juror is looking over at them and at the jury, and any thing I could think of why you would want a lesser included of manslaughter as the defense is if you're picking up on something that you really think, boy, we better have an out for them on this.
I don't get it either. I feel like they should be at a place where they're looking at, you know, giving the jury acquit or don't. But I mean, the other thing they've got to consider is sentencing is Judge Cannone, and where's she going to land on the 2 to 20?
20, I'm sure.
Yeah, I mean, she's going to be like, well, defense makes some great arguments, so I'm going to, you know, cut it down to 19 and a half. So, I mean, maybe they're figuring that if they've got to go to an appeal, they can get a verdict of acquittal on the highest, and then get the trial flipped and force a trial just on that theory. I don't know. I don't understand it, and there's a fair number of decisions where I'm like, I don't necessarily understand this, but I suspect we'll learn more about why these decisions were made later, because sometimes trial strategy is not clear from the outside because we don't have all, you know, access to all the information. So it does seem odd to me, though.
Yeah, the whole thing seems odd. I mean, the lesser includes are for the manslaughter count. Basically, like there's like 2 or 3 versions they charged last time, because you got murder count 1, manslaughter count 2, and leaving the scene of the accident count 3. And so the lesser includes were all with respect to count 2, the manslaughter count, and different versions of manslaughter. And so, those presumably have some sort of differences in sentencing impact, presumably. But yeah, that the different theories of the way to get there. So I just don't know why you wouldn't why you give them another opportunity to find a compromise by giving them like 2 or 3 different versions of the way to get to a manslaughter conviction. It seems incredibly odd to me, as opposed to holding them to the highest burden. I don't quite understand. I understand the choice, like in principle, like I understand how in some circumstances how you could be faced with a very difficult choice. But as to the legal sufficiency of the murder charge, I think I'm actually going to disagree for legal sufficiency. And I think we can discuss this by we lost him, so maybe he'll come back, hopefully. But we can discuss this, and we'll discuss this probably in a separate video as well, because I was thinking about doing a video on this point anyway, as to legal sufficiency of the verdict. Where'd my or legal sufficiency of a guilty verdict, to be more proper. So here is murder in the second degree, which is what she's being charged with. So let's walk through murder in the second degree and walk through legal sufficiency for a conviction. So in order to prove murder in the second degree, the Commonwealth must prove the following. The defendant caused the death of the person, which, is obvious. Right? The defendant caused the death of the person in some manner, some way that she caused it. And then the defendant, and here's, because that's just causality, right? The cause and fact.
Yeah.
And then as to the other elements, the defendant, one, intended to kill the victim. So my goal is to kill you. That obviously is not what the state is alleging here. Or intended to cause grievous bodily harm. In other words, I'm trying to beat the shit out of you, and I just went too far and you died in the process. That isn't what happened here. I wasn't like trying to beat the shit out of you and you just died. Or, and this is the one where that they're trying to prove. Intended to do an act which, in circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood death would result. So let's walk through it. So first of all, what do we mean by intent? Well, intent is mental state, and it means that I am trying to do the thing. In this case, the thing I'm trying to do is the act, not the death, but the act. So it's as opposed to negligent, as opposed to reckless, as opposed to merely knowingly, I'm intending to do it. So it's not that my foot slipped on the pedal. It's not that, I thought I was in drive, but I really was in reverse. I intended to drive in reverse. I was trying to do that. So that's one of the things they have to prove. And then the other thing that they have to prove is the circumstances known to the defendant. So she has to know about those circumstances that a reasonable person also would know. So she has to know in fact, and also a reasonable person would know that creates plain and strong likelihood. Now, critically, knowledge can be inferred from conduct. So the requisite knowledge can be inferred from the act itself as a matter of black letter law. So if you conclude that she intended to do the act, you can also infer that she knew of the circumstances that caused her to want to do that. Namely, that John O'Keefe was behind her and that she was accelerating rapidly in his direction. Again, not necessarily even towards him, because it only has to create a plain and strong likelihood death would result. So if I knowingly, or if I purposely drive backwards, knowing that you're behind me, even if I'm not aiming for you, I think you can make a pretty credible legal sufficiency argument that, that there is a plain and strange likelihood of death. And so I think you're there on a legal sufficiency basis. But that's in the light most favorable to the Commonwealth, of course, because that's how you view things when you're talking about legal sufficiency. But that's how I view the circumstances here. There's a lot of reasons to reasonable doubt, but if you view things in the light most favorable to the Commonwealth, I think you have legal sufficiency. So, Travis, I don't know if you have anything to say about that, but I'm interested.
No, I agree, Kurt, 100%. And where you see that subsection C, where you see that a lot is if someone's using a firearm and they shoot into a crowd. They don't intend to kill any particular person.
Right.
But hey, shooting a gun into a crowd is known to any reasonable person to create a plain and strong likelihood of death, right? So, but prosecutors across Texas have when it's intoxication, manslaughter is what the offense is in Texas. You don't need to show intent, but sometimes they will charge the higher level offense of murder, and where we have this language where it's plainly intended plainly. The motor vehicle enhancement, that factors in sentencing in Texas, that if you, and I don't know exactly the way it works in Massachusetts, maybe Runkle does, but if you prove that motor vehicle was used in a manner that it was a deadly weapon per the instruction, that means you're ineligible for probation in Texas. And that's why they have that enhancement.
Yeah. So to take our firing a bullet example, driving a car into a crowd of people, it's like I purposefully, of course,
Yeah.
mind you, but that's going to create some risk, and someone might die as a result of that. So
And I don't
you're
I don't
you're
think
doing
probation
something
is
that's
the biggest
inherently
worry for anybody.
Yeah, that's not the biggest worry. So yeah, I think again, you have to sort of get to a combination of the evidence. But I think unfortunately, and I don't necessarily want to be true, but I think there is a combination of the evidence that would allow a jury to conclude proof beyond a reasonable doubt, because as the judge will explain to the jury, you're the trier of fact, which means not only do you get to determine what's true, but you also get to determine how much it matters. And so basically the question is, well, can they believe evidence in some combination? And then from the evidence that they choose to believe and the evidence that they choose to weigh, then from that pool, get to beyond a reasonable doubt. And I think the answer, sadly, to that question legally is yes. I don't see it being overturned on a legal sufficiency ground, as opposed to trial number one, where I think it was much more in dispute. But here on legal sufficiency, I think the Commonwealth has legal sufficiency. It requires you to disbelieve ARCA. It requires you to, but maybe. I mean, yeah.
I mean, one of the things that people hate when lawyers are discussing this is, if we say like there's enough to go to the jury, keep in mind this is on the Commonwealth's best version of evidence. And the Commonwealth's best version of evidence is not going to be your version of things as a viewer. It's going to be, what if they accept everything that the Commonwealth's witnesses say that is good for them, and none of the things that they say that are bad for them? And what if they completely disregard everything the defense said, except to the extent that it also harms the defense? So it's basically what is the worst case scenario for Karen Reed of, you basically have to imagine the most biased juror who still has enough conscience that they need to be able to show their work.
The middle 90%, not the middle 90% of jurors. So we'll exclude the 5% crazies on either extreme. But if you're anywhere in that middle 90%, man, it's you're there.
If any one of them could say, I convict. And I mean, it's basically, so long as you can thinly rationalize it, but still rationalize it, it goes to the jury, it goes to, and so, as an example of this, I had a case and it was a judge alone trial. And at the end of it, he asked, Mr. Runkle, do you have an application to make? Which was a very strong hint that I should make the application to dismiss.
Yeah, you know exactly what that means. Of course you do.
And so I make the application and he spends 15 minutes denying the application and noting that, notwithstanding that the evidence in this case is very thin and substantially destroyed on cross-examination, and the massive credibility problems with the prosecution's witnesses, there's still enough that and the prosecutor didn't read the room, didn't take the hint on that one, and still went.
You didn't take the win? Wow.
But then the judge, so after denying me extensively, the judge is like, Mr. Runkle, are you calling any evidence? Which was an obvious no, when the judge has very much signaled where they're going. And prosecutor argued for conviction, and I got up and the judge is just like, I don't need to hear from you. We're good. And but it
was the judge fishing for you guys to work it out in the meantime, Runkle, or
the judge was fishing for the prosecutor to figure it out and to drop the charge? It was very much a read the room, prosecutor. Your case is garbage.
Okay, gotcha. Yeah.
And I mean, I think he was hoping that the prosecutor, after hearing that, would just be like, Your Honor, we just invite dismissal, and that would be it. But instead, they argued it, and the judge just like, okay, here we go. But the point of all of that is that even though the judge is like, this case is absolute garbage, there's still enough that it can be argued. So we got to argue it.
Yeah, and so it's a little bit on the defense side. here when the defense wants an instruction. We heard earlier before the end about the Bowden and then the third party culprit, and then a little bit of argument about what the defense was intending in terms of Higgins. Were they intending to, did they want a full-blown third party culprit instruction, or did they just want to be able to argue as part of the Bowden that there wasn't a good enough investigation to determine whether Higgins was a viable third party culprit? So what the defense needs in order to get an instruction, so it's the other side, if the defense wants something, all they need is a scintilla of evidence that supports their theory, and they're entitled to the instruction. If you don't get it, it's structural error, and it's an automatic reversal. So judges, and I'm sure it's similar in Massachusetts, be interested to see what it is in Canada. But if you have some evidence of a defensive theory, just the slightest amount, that's all you need, and the court must give that instruction.
In Canada, the term would be error of reality.
Oh my
So,
gosh,
like,
I love that.
Error
yeah,
of reality.
it's just,
I like that.
and error of reality can come from either like defense evidence or like prosecution evidence. As an example, I do a bunch of self-defense cases. So error of reality as to whether or not there can be a self-defense question comes up a fair bit, because you'll have somebody who's like, you know, we got into a fight. And I'm like, well, them getting into a fight raises an error of reality, probably on self-defense, so long as it isn't something like, you know, if my client walks in, like picks a hotel room lock, finds a person sleeping who he's never met before and starts beating him with a brick before the guy wakes up, I'm going to have a real hard time establishing an error of reality to self-defense. But if there's two guys beaking off in a bar, even if my guy throws the first punch, I still have error of reality on the table, most likely, because sure, my guy might have thrown the first punch, but he might have done so because he imminently anticipated that he was about to get, about to get his skull beaten in. So and then once you have the error of reality to put it to the jury, it's up to the prosecution to prove beyond a reasonable doubt that it wasn't that. So, it's like, so long as there's basically more than nothing on self-defense, the prosecution has to prove beyond a reasonable doubt not self-defense, which can be hard in some of these like fist fight cases and so forth. So
yeah, I believe it's law now in every single state. Ohio actually had the burden on the defense for self-defense for a while, but I think they finally gave up the ghost too. So I think in every state now it's up to the prosecutor to disprove self-defense. So yeah.
It's the same way in Texas. If they give the instruction, the jury's instructed that the state has to prove beyond a reasonable doubt that the defense doesn't apply. They have to prove a negative. And all of my cases, defending police officers primarily who have been involved in some use of force, typically a shooting where someone ends up seriously injured or dead, it's justification and self-defense under our justification statute. And yeah, it's always coming up. And the lesser included of criminally negligent homicide, we're always on the horns of a dilemma, Hobson's choice. Do we want to offer that if the state doesn't? And in Texas, if the state wants it, as it is in Massachusetts, if it's a legitimate lesser included, the court has to give it if asked by the state, pretty much the defendant also. But if the state doesn't, do we offer that up? And it's a really, really tough choice. But Kurt or Runkle, remind me, the lesser includeds of manslaughter were those the intoxication offenses? They're not.
Yeah,
were
yeah, they were.
Yeah.
There was DUI, ODI, manslaughter.
they?
Yeah,
Okay.
yeah, that was it.
There's so I could see. I mean, that Melanie's Law one, I think, is 2 to 15, but what Melanie's Law did is made it mandatory you had to serve at least 1 year in confinement. I don't know if it's county jail or an intermediate institution or a prison, but that's what Melanie's Law did is, and then you could do probation after that.
I mean, there's just no way that if she's convicted that the judge is like, yeah, I'm good with a year. There's she's with the way this judge has been ruling, we'd be seeing
Yeah,
way
it's an
up.
officer who's dead. I mean, don't you know? Yeah, so she's you're. I'm just expecting the max. I mean, you know. So yeah,
And you know, all people are equal, but some people are more equal than others.
So the one thing
I think
never,
I think to be fair, society generally is correct for like being a little bit more pissed when like police officers die and stuff like that because you've deprived the public of their guardian.
So
That's greater harm to the public.
In Canada, there's a sentencing enhancement for killing a police officer, but it has to be on duty or in the course of their duties. Like if somebody, shows up and they're in full uniform and you shoot them, that's, that is a massive sentencing enhancement. But like if you just shot somebody in the woods who was like, stealing your car or something, and it happens that that person's a police officer, it wouldn't be that that's a massive sentencing enhancement, because otherwise you're getting into that person's worth more than somebody else. And I mean, in this case, even the people who are, massively against Karen Read, I think would have to acknowledge that if you think she killed him, it was not for police officer related reasons. It's just that. And I mean, in that case, you should also, if that's the law, you should avoid police officers in every respect of your life, because police officers then become a legal hazard. If you're driving your car and you might have some sort of moment where you drive badly and you might be convicted of it, you better make sure that the person sitting next to you isn't a cop in their life, because otherwise it's much more legal hazard. So stay the heck away from police is the, this is the sort of somewhat ridiculous, corollary effect, but I mean, I chafe at the idea, I guess.
So there's one other lesser included. So going back to why is the defense asking for the lesser included? There's actually another lesser included under this OUI, intoxication resulting in death. There's a misdemeanor form of offense that's been declared by the Massachusetts courts to be a lesser included. And I can't fathom why they're not asking for that.
I don't know what the defense is doing. It doesn't make any sense to me on this theory of the case. I don't know why you would put the drunkenness issue in their mind. Why would you, if your choice is like just straight manslaughter, which is just basically, just a death without the intent to create the death intent. Like why would you like put the idea of DUI in their mind? Like, why would you give them the option of DWI manslaughter? It doesn't make any sense.
That's sure a very, very easy out. And
juries love to split the baby.
Yeah,
they sure do. Yeah, and I don't know why you give them options. Why you give them more bites at the apple? It doesn't make any sense to me.
Especially when you have an hour and 15 minutes of argument. I mean, that's 30 minutes by itself arguing why the lesser includeds don't apply either. If you're the defense in your closing argument, you're saying, well, it's clearly not murder. It's clearly not manslaughter. And it's clearly not these lesser included. It's almost like you're arguing against yourself. typically when, you know, the defense requests a lesser included, it's the state was able, or Commonwealth was able to get in some really damaging stuff. Maybe the way you acted after the incident, what you said after the incident. And it's just really, really damning. And so, you know, we better have a safety net, but I'm not seeing it, Kurt, in the way the evidence came in this case. But again, they have a which I've never ever seen, a juror from the first trial gave them input, and I know that clearly they've changed things. I assume in part because of what that juror had to say, and you know, I don't know if they're getting some sort of a read, as in observing the jury, not the defendant. They're getting some sort of a read from the jurors, but I mean, you've tried enough cases. I don't know about you, Runkle, but you quit trying to read jurors.
Yeah, that could be a bit of a fool's errand.
I mean, yes and no, because sometimes it can be really, one thing I've found is it can be really helpful if you've got somebody else sitting there watching the jury, because some juries, I mean, often they're fairly inscrutable, but sometimes you can get a pretty clear read. And I mean, like the Depp trial, I went down to see the jury and because I was watching this and I was going, okay, they're making good arguments, but you never actually know where the jury is until you can see them a little bit. But, I mean, to a certain extent, a lot of juries are very careful not to reveal what they're thinking and what they're doing, but sometimes it becomes very clear. You know, your defense, you stand up and you're making arguments and you see jurors rolling their eyes. You're like, we're done here. Like, we're going to argue the best we can and try to, you know, but you get that sort of sense. And I've watched juries changing their mind, where the prosecution is finished and they look over to the defense lawyer. I was sort of acting as guy watching the jury in this thing. And, you know, after the prosecution's finished, the defense lawyer gets up and the jury is just looking at the defense lawyer like they hate him. And by the end of it, the jury was like, you know, they see them sort of going, And then when the prosecutor gets up, they were kind of like, you know, given the skeptical expression. I went, all right, this guy's won. This guy's won the jury over. And sure enough, that's where the verdict was. And it was quite a fast verdict. It was basically enough time for them to go out, have lunch, and come back in. But without actually seeing the jury, you can't necessarily know. I'm always concerned when we get jury, like there's people on Twitter doing sort of jury reactions, and I don't know most of them. And so I don't know how much they're actual assessments versus wishful thinking. What I would love to have in that room is somebody who just doesn't care about the trial, like at all. And the problem is we can't, there's no way for that to happen because you don't get into that room without a substantial interest. But I'd love to have somebody who just doesn't care about this and finds it all super boring, but can just report what the jury is reacting, what their facial expressions are. I'm kind of surprised, though, because I thought the defense had a really strong finish.
Yeah, I did too.
Rentschler was amazing.
Yep. They both really held their own very well.
Brennan took his best swing at Rentschler, and it really didn't land, you know. And I could tell it didn't land because when I follow on Twitter, this sort of very anti, you know, Karen Reed folks, they're saying things like, oh, he had a pink tie, he's clearly biased. And I'm like, if he fell on his face, they wouldn't be attacking his tie. They'd be attacking, you know, something else. And then Brennan has no redirect. So he's just ending it on one of the defense's best witnesses. I was kind of stunned at the lack of, you know, the lack of a rebuttal, lack of anything. Sorry, not redirect, rebuttal. I was kind of stunned. I was like, bring somebody back.
Yeah, really.
Yeah,
You
what's
know,
your read on that? That was going to be what I was going to ask both of you, what you thought. Why didn't he call him?
The Twitter people are saying that Aperture said they're done and they want nothing to do with it. That's what they're saying.
I mean, if so, that is massively damaging. But even like discounting that, the defense did a really good job of painting Welcher into a corner. Because if he comes back, what's going to be the big issue? You said there were no x-rays. What is this? Does this not look like an x-ray of the arm? So at that point, the Commonwealth would be finishing either on our primary expert, you know, from the Blue Man Group here that you're supposed to believe is is indicating that this is possible, lied to you about there not being any x-rays. That's one possibility. Or we lied to him, or we intentionally kept him in the dark about evidence that might shake his theory. And all of those are incredibly damaging and even worse to end on. So the defense managed to basically put Welcher into a situation where he can't walk back into that room without getting, a firestorm. And I mean, if Welcher did say, I don't want to come back, it was probably a smart move for him for his career, because like Burgess, I suspect Burgess quietly disappears off the Aperture webpage in like a month, 2 months, 3 months, somewhere there. It'll just be like, they're not going to do it right away.
About 5 seconds after the verdict is read.
They're not going to do it right away because the optics of that would be bad. What they'll do is they'll wait until the furor has died down, and then they will just quietly put out something saying, we congratulate Shannon Burgess on his, his decision to pursue other careers and not the fuck here, just wherever he lands, just so long as, but we're bouncing him. Welcher, I think, might still have a career after this, but not so much if he goes in and gets slaughtered on, on did you lie about, there being x-rays. That might actually. So, I mean, Welcher will probably be testifying in trials again.
So it dawned on me that you guys probably much earlier, you may have already talked about this previously, but it suddenly explained when he said there's no rebuttal. Okay, well, that's why you're asking all of these questions, undermining the state, the Commonwealth, why Brennan is asking all of these questions of Rensselaer, undermining the experiment, the blue paint experiment. Now, he doesn't say anywhere in here that he's using this experiment to show what the location of his arm was. He hadn't used those words. And I'm going, what the heck are you doing? Clearly, how on earth is, what's he going to come back and say in rebuttal? Well, he knew then he wasn't calling him in rebuttal. And so Brennan all of a sudden shifts focus that this blue paint thing, where the, whatever the name of that dummy was, or not the dummy, that he wore the exact clothes, the same clothes that the deceased was wearing, doing everything he possibly could to make these two situations almost exact as possible. What else would it be? But now I understand. He figured out he needed to shift focus and try and argue that he wasn't using that experiment to demonstrate something. It was the most baffling thing I've ever seen.
Yeah, that's a whole other set of things. But Runkle, before you have to head out, I'm just curious, what do you think is the percentage probability of conviction based on what you've seen at this trial?
30%, somewhere around there.
I'm saying 20, but yeah, I think this is plausible. Yeah.
So she didn't update she's not going to give the jury slip that the defense offered, which is
she's thinking about it.
If she clears that up, and which is the way the verdict forms are here. I think it's 30% on one of the lesser includeds of a guilty, 10% on the ones above that. If she does not, if we end up with a slip that's similar to the last go around, 40% on one of the lesser includeds, guilty.
Yeah. This sounds plausible.
I've never seen a prosecutor retreat from their own theory and invent new theories the way we saw with Rentschler. Like, isn't it possible he could have stumbled against the curb and Rentschler's like, is that just a new theory? Like right now on cross, you don't know where he was or how he was positioned. I'm like, the defense doesn't know where he was and how he's positioned because you haven't figured it out and you have no plausible theory of how this occurs. Quite frankly, I was also just stunned. I was glad to see Rentschler calling out the science that Welcher was doing, because I could give that, his experiment to a first-year psychology student as an example of like, spot the problems in research design. And I think this is a fundamental issue with how the courts deal with expert witnesses, which is that our standards are way too low and our judges don't actually understand what science is.
Yeah,
and
I tend to agree it's too low, unless, of course, you're a defense witness, in which case you must be the best expert ever, and then maybe it's still not good enough.
But we've allowed this. These experts to testify in ways that are dramatically unscientific. The whole, I'm my own crash dummy is ridiculously inappropriate. And, for the reasons Welcher put in, consciously or unconscious, or sorry, Rentschler, I'm doing the doing the same thing Jackson was, but consciously or unconsciously, once you have a theory you're trying to test, you may end up doing things to affect the test in that way. So when you see him leaning into the car, somebody who didn't know what the expected pattern was wouldn't lean like that. They wouldn't do that. And so you can only get the result Welcher got by knowing what the goal is and by basically consciously or unconsciously trying to get to the goal. Whereas if they just if they brought in some random intern, they don't let the intern look at it. And they're like, hey,
bad intern assignment, man. Stand in front of this car.
Stand in front of this car. We're going to bump you with a car at low speed. There's no way you get the same pattern. And the other thing is that if I'm looking at designing Welcher's test, which I wouldn't do it the way he did it, I'd probably fill a human mold with ballistic gelatin or something like that and then put a shirt on it. But he put a solid block of paint. And what I would have done is put paint dots. And the reason why the paint dots is because the paint dots will show you what kind of pattern you'd be looking at from scratches from a vehicle. And the reason why we don't see that is because there's absolutely no way that pattern of dots would have ended up with the way John O'Keefe's injuries were. It is, the more Brennan tries to prove his case, the more I'm just like, they are cutting corners and they're actively disproving the issues that they want to prove. I saw things from their case that convinced me that, that there was evidence tampering. I have no way to explain that little piece of glass that's found on the bumper that is only a match to road glass and not to the drinking glass, and not like, how do you get that? How is that possible? It makes no sense. The only explanation I can think of is planted evidence. This is the weirdest case, and I hate this case because I want to talk about it with friends here who are all lawyers. and they're not following it because it's Canada, and we're probably not, most people here aren't following a US case, but I try to explain this case to them.
Having trouble time with that one?
And they think I must be bullshitting them because they're like, there is no way that's actually what's happening in court. There's just no way that the prosecution is continuing on this. And I've had people give me like angry, skeptical reactions because they're like, you know, don't bullshit us on this. Like, it's not, I just don't, I hate this case. I hope we get a clean acquittal so that it's just done, because
That'd be
this
nice.
case stresses me out.
Remind me, what province are you in, Runkle?
Alberta.
Oh, beautiful. Love it. Been to Banff many times. Beautiful,
Oh.
beautiful, beautiful country. But so how does it work in Canada if you're licensed? Are you licensed by province or the entire country?
So we're licensed by province, but there's a reciprocal agreement that allows for doing a certain amount of work out of province without getting, licensed in the other province. But if you do a lot of work in a particular other province, you should get a license there. The main exception to that is Quebec, and that's because Quebec has separate rules. They actually use a civil law system for a lot of, as opposed to common law for a lot of their,
Just
it's
like Louisiana, except Louisiana still follows the Napoleonic Code.
Same for a lot of Quebec, but the criminal law is actually because of the way powers are divided between the federal and provincial governments. Criminal law is a federal power. So because of that, criminal law is harmonized across the provinces. But if you want to do like wills and estates, it can be dramatically different between one province to another. So I do criminal and firearm stuff. So I have done things where I hop into other jurisdictions to run a case. So yeah.
How are we going to get the jury slip when it's finalized? Who's in charge of getting us that?
The media released it last time, so hopefully they will this time, along with a copy of the jury instructions so I can review them and see if there's any differences. It'd be nice for jury watch.
What did she end up ruling on? I was having technical difficulties. I think y'all talked about it, but they wanted the instruction on the cuts on the sweatshirt repeated.
I don't think she made a ruling. I think she said she was going to think about it.
Yeah.
She really should, though, because that was the worst cautionary instruction ever. You need a little bit more like, flair when you're giving that instruction rather than just like, oh, by the way, these were caused by this. It's like you need a little bit more than that.
Last thing I'll
was
say,
the worst cautionary instruction ever.
Yeah, last thing I'll say before I bounce is that curative instruction was so minimal. It was like a half sentence delivered in a complete lack of interest for massive, jury misleading. As the curative element of it is like finding somebody with a gunshot wound and going up and putting a little finger band-aid on it and being like, we're good here. So thanks for having me on. I've got to bounce, but we'll have to do this again sometime soon.
Nice to meet you virtually, Runkle.
Likewise.
Always enjoy hearing you.
Well, thank you, and we'll have to do this again soon as well. So cheers.
Cool.
Kurt, what's your over-under that it's going to be another mistrial for unable to decide?
I really hope not. I haven't dared to give out a mistrial.
I'm sorry. I screwed the whole thing up. I was really hoping that arguments were going to be Monday. I always hated arguing going into a Friday.
Yeah, I mean, because Fridays, juries sometimes don't want to come back on Monday. So Fridays sometimes incentivize
and
settlements.
They will cut deals, and if you got
which makes lesser included all the more scary if I'm the defense, because I'm giving them more outs. It's like, let's just agree to like whatever, so we can all go home.
The more I think about it, I'm equally perplexed. And you confirmed. I heard the word, and they weren't in front of microphones, and Lally was the one that said, and I could never make it out. I have full confidence that you were finally able to figure out what
I couldn't tell what the word itself was, but from the overall context, it was clear that it was not offering it. So I couldn't tell from the word, but based on everything else, that's what he was saying. So
yeah, if that turns out absolutely to be the case, it's very perplexing. I just can't think of a reason why you'd want to do that.
Yeah. All right. Well, let me end this. Let me bounce you for now. I'm going to do a little recording trying to summarize some of these issues relating to legal sufficiency so I can post it as an excerpt. And then I've got to file a notice of appearance.
Thanks for having me on. Good to see you. We'll see you soon.
All right. Talk to you later. Bye-bye.
Bye.
All right, chat. It's just you and me for a while. We're just going to do a little excerpt here that I'm going to cut out and film or release as an edited video. And then I got to file a notice of appearance. Exciting. I'll tell you more about the case later. Maybe. It's actually, no, it's a trial. Civil case. I'll tell you it's a civil case. It's in Texas. That's what I'll tell you for the moment. And I'm trial counsel in a civil case. So exciting. I'll tell you more about the case later. Can you be your mock jury? Absolutely not. All right. Absolutely 100% not. Love you, but no. All right, cool. So as I'm sure many of you are aware, I have been predicting probabilities relating to Karen Read being convicted at various times in this case, with a high probability of 66%, I believe was the highest probability, and currently estimating a 20% probability of conviction on count 1 or count 2. And so what I thought I would do in this video is try to explain how I am getting to that number, because sometimes people ask, and I thought I would try to explain where that number is coming from, and also some other factors. So first of all, we need to, of course, start with legal sufficiency, how a jury can legally get to beyond a reasonable doubt. And to start, we're going to just do the murder, because obviously the murder is the most interesting, and we're just going to work through that so that we can analyze it. All right, so first of all, we have to start with the elements of murder in the second degree in Massachusetts, because the elements of murder, of course, change from jurisdiction to jurisdiction. So here is what the Commonwealth needs to prove beyond a reasonable doubt. They need to prove each and every element of the crime beyond a reasonable doubt. Beyond a reasonable doubt is sometimes said by lawyers, depending on who you ask, is something like 95 to 99% certainty, something in that order of magnitude. So we have to be 95 to 99% certain that these things are true. And if all these things are true to a 95 to 99% certainty, then we would convict. So what are the elements of murder in the second degree? Well, there are two major factors. We have 1 and 2. 1 is causality, cause in fact, and 2 is the things that she did. All right. So with respect to 1, the defendant caused the death of the victim. I mean, that's pretty clear in and of itself, right? That's just straight cause and fact. Whatever she did caused the death of the victim. And of course, that cause doesn't need to be the sole cause. It just needs to be a substantially contributing cause. So for example, if she had knocked him down and he was immobilized and that didn't kill him, but the fact he was immobilized led to him being killed by, take your pick of whatever, hypothermia or dog attack or anything, right? If she created the conditions by which he died as a consequence of that, then she'd be responsible for that. So obviously she's responsible if what she did directly killed him, but she's also responsible if it indirectly killed him, as long as it was a substantial contributing cause, like, for example, frostbite or dog attack, right? So she has to have done something to cause it. I mean, that part's pretty clear. And then element 2, the defendant has to have done one of the following 3 things. First of all, intend. And when we say intend, we mean it is the purpose and goal. It is what we are trying to do. It is our objective. It is our desire. It is what we are, it's what we are aiming to achieve. That's what intent means in a legal sense. So we intend to kill. In other words, I want you to die, and then you died. That's murder, okay? Or I intend to cause grievous bodily harm. For example, I'm intending to beat the shit out of you. That would be an example. And, you died. I wasn't trying to kill you. I was just trying to beat the shit out of you, but you died, and I'm responsible for your death because I just punched you a little too hard and sucks to be me, for example. Or what's going to be true in our case is C. And this is where we're going to spend some time focusing on. Intend to do an act. So here the intention is not to kill. Here the intention is to perform the act. Okay, the act, which in circumstances known to the defendant, so the circumstances have to be known to them, and by knowledge we mean they actually know, or we mean that they're aware to a high probability. So they don't have to know for certainty. The law allows for them to know to a sufficiently high probability. So as long as they have knowledge that is sufficiently highly likely, that's considered knowledge. A reasonable person would have known. So not only do they have to know in fact, or to a reasonable degree, but a reasonable person, that is the reasonable man would also have known, creates a plain and strong likelihood that death would result. So an example of this would include, for example, if you drove your car into a crowd of people, okay? So here, we're not trying to kill anyone. That's the premise of this. It's not my goal to try to kill anyone. I'm just establishing that as a fact because, I'm God of the hypothetical and I'm telling you, right? I'm driving into a crowd of people. I'm not trying to kill anybody, but I intended to do the act. I intended to drive into the crowd. I have knowledge, namely that the crowd is there. I know they're there. The reasonable person would also know the crowd is there because, with their eye parts. And we know that that creates a plain and strong likelihood that death would occur. If you drive your car into a crowd of people, then, that's probably, that poses some real serious risk to people. So that's not particularly difficult here, right? So the intention is to perform the act with circumstances known to create a strong likelihood. Again, I don't have to know that death will occur. I don't have to know that it's certain. I don't even have to know that it's like really, really likely. I just has to create a plain and strong likelihood. So it can't be trivial. It can't be a trivial possibility, but it doesn't have to be a certain possibility either. All right. So how are these elements met legally under the state's theory of the case? How are these elements met under the state's theory of the case? Well, she caused the death of the victim, namely by the car hitting him, which we'll get to in a second. That would be the manner of that would be the thing that did it. The defendant caused the death, namely by hitting him, whether directly or indirectly. The hit itself killed him, or the hit disabled him, and he lied prone on the ground and he died from hypothermia, or he died from a heart attack as a result of the stress, or he died from a dog bite, or he died from, succumbing to his wounds in some other way. That's basically a theory of the case, right? The defendant hit him with the car. And that she intended to do so, intended to drive the car into him or towards him more properly, right? So by intent, again, we just mean it's our purpose, our goal, our intent to do the thing, namely driving backwards. I wasn't confused. It's not that my foot slipped. It's not that I thought I was in drive and, I really was in reverse, right? That wouldn't be intent, right? Here, I knew my car was in reverse. I purposefully pressed the accelerator pedal and I'm driving backwards, and she intended to do that, okay? And then circumstances known to defendant. Well, the theory is that this happened after Miss Reed dropped him off for this party and then basically changed her mind and decided, you know what, I'm going to drive back towards him, not necessarily to kill him. I'm going to drive back towards him to try to scare him, perhaps. Maybe that's her objective, but she knows that he's there. And also, by the way, of course, she would have been drunk at the time. So, but you have to eat that, right? Because if your perception is off because of voluntary intoxication as opposed to involuntary, right? So if you were intoxicated against your will, different story. But if you intoxicate yourself and your perceptions are off, then you just have to eat that, okay? In this kind of situation, because this is general intent, or in this circumstance. So basically, she intended to drive backwards because she was really mad, maybe to scare him, or maybe not necessarily to do anything, but with knowledge that he was there, which of course she would have because she just dropped him off. And again, it's only to a sufficiently high probability, so maybe he walked off, but you know, he would still be in the zone of danger or close to it. And also a reasonable person would know that if you drive backwards, you know, towards somebody, that's creating a strong likelihood of death, right? Because you might hit them. Again, maybe you're not trying to, but maybe your car slips, maybe the tire slips, maybe your hands slip, maybe the car accelerates the wrong way. But, you know, again, you just kind of eat it at that point. And so that's sort of the state's theory of the case on how all that applies. Okay. So that's how we get to murder in the second degree under the state's theory of the case. All right. So then we have to sort of analyze, all right, what is the probability of the jury concluding all the things I just said? Like, what is the probability of the jury making those findings? All right. So in order to assess that, we have to remember two things. We have to remember that the jury is the finder of fact. And that means, and also the finder as to the weight of the information. So the jury is literally the determiner of what is true and what's not. That's literally their job. So first of all, is it true or is it not true? And second, how much does it matter that is true or not true? Is up to them. So the question becomes, can the jury, in analyzing the evidence, make some combination of the evidence reasonably that would allow them to do that, right? So it's up to them, for example, to judge the relative strength of the witnesses, including expert witnesses. Expert witnesses are judged by the jury the same as any other witness, not for at least the reasons that expert witnesses sometimes are full of shit. And I think that you would agree with me that some of the expert witnesses in this case were probably shit. So you're going to rate those experts and their credibility. You've already done it in your mind. You've already assessed how likely what they're saying is correct. You've already assessed how much you believe them. You might believe them in some elements and not other elements. You might disbelieve them all completely, but you've already made this assessment yourself. And so the jury, of course, gets to make that assessment, but critically, of course, they get to make the assessment for themselves, and the way they believe things and the weights they give things are almost certain not to be the same as yours, just merely because you're not the same people, right? So how they assess the strength of those experts, how they rank them in terms of their credibility, the strength of their presentation, the information they're given, their scientific reliability, how they're rating those witnesses is definitely not the same as your rating, because how could it possibly be the same? Because they're different people, and maybe somewhat radically different from yours, depending on who's making the assessment, right? The credibility, for example, of Jen McCabe, the credibility of, for example, the state's data forensic person or the defense data forensic person, like all these people. And then, of course, the witnesses relating to various things, like how are they to be assessed? How good is their memory? How much does it matter that they can or can't remember certain things? How critical are those things? And so forth and so on. So what you sort of have to remember from a legal posture is that the jury is allowed to sort of make any reasonable combination of the evidence. And that is a pretty wide swath. So that's like the middle 90%, if not more. So if you take like all the possible ways of assessing the evidence, right? If you could just like imagine in your mind, like you literally believe everything the Commonwealth says and nothing the defendant says, would be like one scenario, I suppose. And exactly literally the opposite of that, you believe everything the defense says and literally nothing the Commonwealth says, right, would be another extreme of that. So if you take sort of the middle 90% of all those possibilities, that is what's sort of in the legal allowed range. Maybe it's the middle 95%. So we're willing to exclude, the 5% or the 2.5%, on the far margins either way, right? When we're sort of making this assessment. But we're allowing a very, very wide swath. So when you're sort of assessing this and sort of the probability, you have to assess the probability that the jury is going to land on one set of that extreme versus the other set of that extreme. And what is the probability of that happening? How many ways are there for them to get them there? And so that's one of the things that, the pro Karen Reed contingent, I think, somewhat underestimates here. They somewhat underestimate. They are more than happy, and they will tell you in excruciating detail all the many weaknesses of the defense, of the prosecution's case. The free Karen Reed people are very, very happy to explain to you the faults of the Commonwealth's case. And I tend to agree with them. Maybe not quite to the degree they do, but we are basically simpatico, the free Karen Reed people. We might quibble on some stuff, but not in a way that's really going to get anyone's dander up. We basically agree in substantive part, right? As to me personally, I think that the state's case is shit. And I've said so every single time, and I've never deviated from that position. I think the case is shit. But we have to I think what the free Karen Reed people somewhat tend to discount is that, unfortunately, for Karen Reed, people come in all kinds of varieties of flavors. They come from all kinds of backgrounds of life. Some people are more diligent. Some people are less diligent. Some people are more attentive. Some people are less attentive. Some people are more logical. Some people are less logical. Some people are more emotional. Some people are less emotional. Some people tend to trust the government and the police. Some people decidedly less so, right? So we have to sort of remember in our heads to sort of get out of our own perspective, which can be challenging. We have to get out of our own perspective and remember that there are people who think things genuinely in ways that are somewhat radically different from you and I. But as long as they're within that sort of 95% window, right? As long as they're within that 95% window, they are legally within the bounds of what a reasonable jury can do, right? Basically, we're not going to do it. Basically, the courts are not going to step in unless it is batshit crazy, right? That's basically the threshold. So from a position of legal sufficiency for conviction, right? From a position of legal sufficiency, since the jury can do anything within the middle 95%, we have to assume from a position of legal sufficiency, they will do anything within the 95%. We have to assume the worst possible case legally because they can. We have to assume that and ask, can they convict in the worst possible case? If we're in the 5th percentile or 2.5 percentile, right? If we're in that sort of category and that's where we land, could the jury convict? And I think sadly, the answer to that question is yes. And, it's not particularly difficult to get there, unfortunately. First of all, if you believe that the the plastic pieces of the taillight really were there the entire time, right? Which is a thing a person could believe, right? The police just weren't able to find any of those taillight pieces, despite their efforts. And then later they came by and they just happened to be there. They were there the whole time to be found. And somehow they didn't see the red things in the snow. They're not very good at their job, but the police being incompetent is, of course, always an option, as I'm sure the free Karen Reed people are more than willing to admit, right? The free Karen Reed people, I'm sure, are more than willing to admit the police being incompetent is definitely a decided possibility. So unfortunately, that incompetence goes both ways. And that incompetence could mean that they weren't able to see the red pieces in the snow initially because they're just a bunch of dum-dums. But they really were there the entire time, right? That is a thing a person could believe. And if you believe the taillight pieces are there, well, then the accident had to have happened because otherwise how the taillight pieces get there, right? The accident had to have happened. And then, well, what did it hit? If not, John O'Keefe, what else could it be? There's not a lot of other scenarios, and no one else has really provided any scenarios. No one else has provided really any evidence, and we're not allowed to speculate. We can't speculate. We're allowed to make inferences, but we can't speculate. So there's really nothing else other than John O'Keefe that's been suggested that she could have hit. There's really no evidence other than that of John O'Keefe. So it must be John O'Keefe. And if she hit John O'Keefe, well, then you're kind of there, or you're at least a lot of the way there, right? Then you just assume that she hit him intentionally, or apologize, not that she hit him intentionally. That's wrong. That she drove towards him intentionally because she was mad. She lost her temper, as sometimes people do. She lost her temper. We heard phone calls with her being very, yelly and screamy. So we know that she can have a temper, so she lost her temper and she drove backwards, and maybe she wasn't aware that she hit John O'Keefe. Maybe she didn't know that she hit him. That's possible, but she doesn't have to know she hit him. She just has to intentionally drive backwards, knowing that he's there. And if she didn't know she hit him, well, that's neither here nor there as it relates to the murder charge. Maybe leaving the scene of the accident, but not as to the murder charge. So, if you believe the taillight pieces were there the whole time, that gets you a long way. Karen Reed's own statements, right? You had Jen McCabe who said, I hit him. Jen McCabe said that. And there was at least 2 other EMTs or police officers who said that they heard her say, I hit him. And confessions go a long way, as we've discussed many times. Confessions can sometimes overrule physical evidence. So that's that. And then as to why, the injuries were less severe than you would expect, you could make some potentially reasonable conjectures. I mean, very little certain in medicine. And so, the fact that the car could have hit him and not left bruising or, left torn ligaments is implausible, but it's not necessarily impossible, and not so implausible as to be beyond legal reach, right? That it's plausible enough. And it's not unlikely, but it's not so implausible as to be not something a jury could reach onto. So you sort of have legal sufficiency, so from a legal standpoint for those reasons. And then of course there's other evidence besides, but that kind of, gets you most of the way there. John O'Keefe is obviously dead. If you believe the taillight pieces were there the whole time the collision happened, if you believe the collision, if you believe she confessed or admitted, then that, gets you there. And, basically Bob's your uncle at that point. And so okay, I mean, you do have to disbelieve Aperture, or apologize. You do have to disbelieve ARCA, but of course, weight is up to the jury. And so maybe you find ARCA not to be particularly persuasive. I mean, maybe you think that their shills are not telling the truth, or their scientific stuff isn't particularly good, or it's just self-serving, or whatever you think there. So, people disbelieve expert witnesses for all kinds of reasons, or you just don't like scientists, so you don't believe them for that reason, whatever. And so okay, then, all right, so that gets you kind of legal sufficiency. And then it's okay, so in assessing the probability of conviction, then once you sort of get to the point of legal sufficiency, once you do that, you sort of have to start running some, back of the envelope numbers. So how do we get to 20% to convict? Well, or how do I get to 20% to convict? More of the point. It's well, I think that there's a 5% base chance the jury convicts just because there's a defendant sitting at the defense table. I think that's pretty much just a given. They must have done something. They're sitting at the defense table. And if you don't think that that's a factor, you're out of your goddamn mind, right? And you may disagree it's a 5% factor, but if you don't think that if you don't think it's a non-negligible, they must have done something. There's a reason they're saying it. If you don't think that's a factor, you're out of your goddamn mind. All right. So that's all I have to say about that. All right. It is a factor. If you want to say it's less than 5%, so be it. But I'm going to say 5%. There's a 5% defense, there's 5% chance they convict just because there's a defendant sitting at the defense table. Because, they must have done something. We trust the police, which is, again, some people do. We trust the government, those factors are non-trivial. So I'm going to assess 5% based on that alone. You then add in, I think, the fact that a cop is dead, even though not in the line of duty. I think that ups the odds. No one really likes dead police, or I shouldn't say no one, but most reasonable people don't really like dead cops. The cops are supposed to be our protectors, and a person who kills a cop removes a protector from society. So it's a greater societal harm. Not only have you ended the life of a person, which is bad in and of itself, but you've removed one of society's protectors, which is in fact extra bad. And so I figure, that's got to be worth a couple percentage points in terms of things. And then you sort of land, again, the huge factor here, adding to this equation of 20% is the confession, the admission, right? That Jen McCabe and like two other witnesses said that they heard her say, I hit him, I hit him, I hit him. We had like 3 witnesses who said that. There was the EMT, there was another EMT who said they heard it in the background, and Jen McCabe. And I think there might have been one other person who said they heard it, maybe a police officer too. So there was at least 3 and maybe 4 people who said it, right? And then, of course, Karen Reed's own statements in the interviews that she gave, which, depending on how you parse that, could be viewed as admissions. Maybe she was trying to deflect. Maybe she was trying to be cute. But behind it is really a confession. The words itself may not be a confession, but she's just trying to cover for what she really knows happened. She's just trying to be cute about it. So you could definitely view those interviews as being admissions or confessions. That's worth a lot of points in this equation. In my view, juries believe confessions sometimes, up to and including contradiction with physical evidence. They'll just flat out believe confessions in spite of it being impossible. And there are cases that are like that. And if you want evidence of that proposition, then you can consult the Innocence Project. They will be more than happy to tell you about confessions and false confessions and people who have been convicted of with confessions that were not true. And we could point to other cases besides, but just take my word for it. It happens. Not to say it happens every time, not to say it's an ironclad rule of law, but sometimes juries really eat that shit up. Right? So that's worth a couple percentage points easily. And then you throw in, the physical evidence that's there, if you believe it was there the whole time, which is a plausible contention. Remember, this jury did not hear really. They heard Proctor's text messages from one witness, but it wasn't particularly effective, I didn't really think. It didn't really land the way that, it did from the first trial when Proctor was on the stand. So I don't know how much that really plays. They didn't hear from Higgins. They didn't hear from Albert. They didn't hear from Trooper Paul. There wasn't really in this trial a lot of focus, for example, on the mirrored Sally Port video. That didn't really come into play this trial, right? So, which is just as well, incidentally, the defense didn't lean on the conspiracy. They didn't really lean on it, but they didn't really even present a lot of evidence in that domain like they did last time. They didn't really present evidence. And there were reasons they didn't call Proctor, as I've sort of figured out later, because Judge Bev would have, made their life miserable. She would have allowed Brennan the mostest robustest cross ever, I'm sure. And Brennan would have been allowed to make the mostest robustest cross ever. And yeah, I'm sure it would have been very, very annoying. So the defense was probably right not to call Proctor in the end. Although, it's a tough call, but, I think the judge would have made them pay for it with that robust cross and probably was not going to be effective in the end. So, but in any event, the jury doesn't have that information. They can't use what information they don't have. So they don't really have evidence. They don't really have the evidence relating to the conspiracy they did last time. They really don't have. They have the text messages again from Higgins that were read in through Buchanan. They have those text messages, but those text messages, are, I don't know what that is. That's evidence of motive, maybe, but it's not really much beyond motive. It suggests a jealous person or an envious person, but that doesn't really necessarily get you very far. So I don't really think those factors play as richly as they did last time. So you sort of take the fact that there's a lot of pieces of evidence that are missing that were present in the last trial. You take the fact that those aren't really here, and you take the fact that you have the 5% base chance. You up it with the fact that an officer's dead, even though not on the line of duty, but still. You up it with, physical evidence, if you believe that. You up it with the confession. That goes a long way. And I think 20% is a fairly realistic base chance of a conviction on one of the top two counts. We didn't really go through the elements of manslaughter, but I think the point is made without going through the elements of manslaughter, that you're looking with a 20% chance of a conviction on count one and count two. Again, I don't believe it. I think there's reasonable doubt in spades. Personally, I think there's reasonable doubt in spades. But I also think, unfortunately, for you and me, as a matter of law, I think that, again, because the jury gets to decide what evidence is true, and they also get to decide how much to weight it. That's just something the jury gets to do. So it's like, can the jury basically dismiss or weigh out of existence the reasonable doubt? Can they do that in some combination that makes reasonable sense in a very, very broad sense of reasonable? Can they do it? And I'm like, yeah, they can as a matter of law. They can as a matter of law, they can do it. And so then what's the probability they will do it? And and also, of course, we can't forget from the first jury, Ronnie, the juror, we can't forget him, I think, describing other members of the jury, but still, Karen Reed was there, John O'Keefe was there, therefore Karen Reed did it. Yeah, there's that. And 8 members of that jury were apparently ready to convict, even with that case, which I think the Free Karen Reed people would agree, generally speaking, that the first prosecution was an absolute shit show, for better or worse, and whatever it says about his ethics are a whole nother set of problems. For better or worse, and I suppose worse for the Karen Reed contingent, including myself, the factor here that, the prosecution did a much better job of presenting a case is paramount. Again, it was the Commonwealth last time who brought in Higgins and Albert and Proctor and Paul. It was them who brought in all that stuff that made their case more difficult. And still 8 members of the jury were ready to convict on manslaughter. So, if that jury was ready to convict with those shit shows, and you take the fact that I think that the admission, confession was played to much better effect. I think it was sold a lot better. I think they presented it a lot better. You take those elements, and I think, it's definitely possible that, if you just pluck 12 random people off the street, as it were, what is the probability that those 12 random people, without knowing anything more about them, what is the probability those 12 random people will, be, for example, default pro-police, default pro-government, default, whatever. They just don't like Karen Reed personally, which is also perhaps a non-trivial factor. They don't really like her. They find the government's evidence to be more persuasive. What's the probability? I think 20% is a fairly realistic estimate. I think people that are saying 0% or numbers close to 0%, I think they're insufficiently considering the factors that I've laid out. You can obviously weigh the factors I've weighed out differently, because you can assess the weight of those factors differently. But I think that if you are saying 0%, I think you're doing yourself a bit of a disservice. And I think there is legal sufficiency for a conviction, because a jury could, in choosing which evidence to believe or not, and weighing the evidence as they do, then get to beyond a reasonable doubt. Could they? Yeah, I think that's unfortunately legally possible. So that's sort of where I'm sitting on all that. So that's sort of how I got to 20%. That is a very, very long-winded explanation, but a lot of people have been asking and how I get to these numbers. So hopefully I laid that out in sufficient detail to show you my thinking on this. And incidentally, by the way, like I've asked like other lawyers, not everyone, but I've asked a couple other lawyers, and other lawyers tend to generally agree with me relating to these probabilities, although some assess them higher and in some cases much higher. But you know, that's sort of what I think. And for whatever it's worth, Polymarket was sitting at 19%, which is based on real money, by the way. That's how Polymarket gets its numbers. Polymarket is basing its numbers based on people just betting. So that's just what people are willing to bet money on. So the odds are 20% based on what people are just actually betting. And so there is a wisdom of crowd things. The wisdom of crowds is definitely a thing. And so, you know, the wisdom of the crowds seems to be roughly in line with my thinking on this issue. And that is how I came to those numbers. So I will take a few questions at this time, and then I'm going to wrap up the stream. Now that I've been talking and explaining everything, let's see if there's points. You think the defense was much better? I think the defense also was much better. I think that's very true. I think the defense also did a much better job. That's a very, very fair point. So I agree with you. The defense's case was both sides were much better presented. You don't have to convince me that Karen Reed isn't guilty. You don't even really have to convince me that she's innocent. Although, to be honest, that's not my job, right? My job isn't to determine, like, again, like for me personally, my job is really simple here. Like, my job is, did the state prove it beyond a reasonable doubt? That is my job. That's what the jury's supposed to do, right? That's the jury's job. Did she prove it beyond a reasonable doubt? So, like, whether or not she did it or not is not the question. It's, did the state prove it? And that's how we're supposed to think about this legally. I did actually see someone on Twitter recently, and I replied to them, someone who was in the convict Karen Reed camp. And the guy in the convict Karen Reed camp literally said, I don't care what the Commonwealth can or can't prove. And I'm like, dude, that's the goal. What do you mean you can't? You don't? Karen Reed did it. That's all I need to know. I don't care what the Commonwealth can prove. What do you mean you don't care what the Commonwealth can prove? That's the goal, man. That's the assignment. But there are people out there. There are people like that out there. I know that they're out there, and I know it's not just this Karen Reed person who said it. I've seen other people say that too, more than a few times. That also is a thing. As we're factoring in the probabilities here, there are people, and apparently not an inconsequential number of people, to be honest, who think all this stuff about reasonable doubt is just a bunch of legal gobbledygook. And they don't care. They actually just don't care. They don't care about the lawyers. They don't care about these phrases like reasonable doubt and presumption of innocence. They actually just don't care. That is I don't know what percentage of the segment of the population that is, but I know it is non-trivial. If it was 1 out of 100, and I think it's more than that, it would still be non-trivial. You know? So, yeah. Do I think most jurors make up their mind after opening? Probably. Yeah. Yeah, probably. And everything else after that's sort of confirmation bias for the jury? Probably. Yeah. I thought, Brennan's opening, and I've said this before and I'll say it again, I thought his opening in sort of its structure was basically perfect. I liked it very much. His stage presence and personality leads much to be desired. But if that had been delivered by someone, that wasn't so repulsive at times, it would have been like one of the best openings of all time. That opening was structurally masterful. It was brilliant, in my view. And so, at that point, perhaps you weren't as dissuaded by his personality, right? Because you hadn't gotten to know him yet. So perhaps you weren't as off put by him. So, there's that. Jackson's opening was also very good, but I don't think was as good structurally. Although what Jackson has going for him is stage presence. And sort of how you weigh those factors, I'll leave up to you. But Jackson's stage presence is far, far better. Its structure, storytelling was not as good, but his stage presence was really, really good. And his use of pausing, his use of vocal variety, like the theatrics of it was excellent. So, yeah. Polymarket has 31% guilty and rising. Really? Polymarket's gone up to 31%? That's annoying. Yeah, Polymarket says 31%. Yeah, sure is 31%. I'm not sure what that was. It was 19% this morning. Now it's at 32%. So, yeah, I'm not sure exactly what that's due to. I don't think it's wildly out of pocket. I mean, 30% is a reasonable calculation. I don't think it's wildly out of pocket. So if they're over, they're not over like in a like. It's not like we're quibbling the difference between 20% and 30%, right? That's kind of a quibble. If it were like 80%, I'd be like, you're out of your mind. But 32%, that's a plausible calculation. You have to like sort of, you obviously have to juice, the probabilities a little bit. You have to juice the, their willingness to disregard the defense as experts. You have to disregard their willingness. You have to juice their willingness to disregard ARCA, disregard the medical experts from the defense. You have to sort of also juice their willingness to accept aperture. But you can do it to get to 32%. It's plausible. I think you're turning up some of the knobs a little high or low, as the case may be, but it's plausible. How does a hung jury figure into that? I have not considered the possibility of hung jury because I just don't want to. I don't know what the possibility of hung jury is. I don't want to figure it out. It just makes me I can't do this a third time, people. I'm not explicitly giving answer for a hung jury. I can't deal with it. So we'll just say that the implicit probability of acquittal or hung is therefore 80%, right? If I think the probability of conviction is 20%, implicitly I think the probability of acquittal or hung is 80%. How those split, I'm leaving to someone else to figure out. I can't do it. %, you're out of your mind. If you think there's an 80% chance to convict, that seems like I'm not quite sure how you're doing that to get the 80% chance to convict. I mean, you'd have to really think that, like, I don't know. I mean, you'd have to really think that I guess you'd have to think that things are better. Yeah, you'd have to think that things are better for the prosecution and worse for the defense in a fairly marked way to get to 80%. You'd have to really like, or either that or just like have no faith in people whatsoever, I guess. But 80% seems a lot. The jury might have some people who don't care and it's Friday. That too. Yeah, Friday. The fact that they're getting it on a Friday does somewhat increase the probability of a compromise verdict because everyone wants to go home. That's true. That's probably worth factoring in. People say this jury tends to run young. I'm not sure how that factors into the equation. I'm not sure what kind of inferences we can make from that, but whatever. All right. Well, I guess that's all for now. Well, I guess I'm going to go ahead and sign off then. I think there were some super chats that, well, there weren't really super chats that came in today, to be honest, but I'll read them anyway. Raw D became an uncivilian. Bluefish gifted 20 gift memberships. Julesh gifted $9.99 for the chess clock sync fund. Crypt Keeper VT gave $5. Texas Katie did. We read that for $5. Bluefish gifted 20 gift memberships. Bluefish gifted 20 gift memberships. Rosemary J gave $5. Says thank you, Kurt, for the in-depth legalities. And J.E. Walsh 7 gave $5 for the Kurt Appreciation Fund. The selection of the random jury is by lot, with the exception of the 4-person, which I'm not sure if that's done by lot or not. I'm not sure. Yeah, she gets to choose the 4-person, but I'm not sure whether or not the 4-person is then in the hopper and she has to re-choose if it's drawn or not. I'm not sure how that works for sure, so I don't want to state for sure. I'm not sure if the 4-person that she selects is taken out of the hopper or not. Selecting the 4-person before it's drawn seems like a bad idea anyway, but whatever. It seems pretty odd that the judge gets to select not only the 4-person, but gets to select one person to be on the jury. That seems like a lot. All right, guys, I'm going to go ahead and sign off for now. I've got to send some letters and I will go from there. So I hope all is well. Cheers for now, my friends. Oh, by the way, we will be back on at 4 p.m. Eastern time. Hold on. Actually, I should set up the stream and redirect you there before I leave. Let me make sure I get this time right first. I don't know. He said 4 p.m. Did he mean 4 p.m. Central or did he mean 4 p.m. Eastern? Let's see if he'll respond back to me. Did you mean 4 p.m. Central time or Eastern? Let's see if Larry will text me back. Either is fine. Just wanna set up the stream. We'll give Larry a chance to text back and then I'll sign off. Everyone do some work in the real world. Yeah. You can watch me address an envelope. That's exciting. Might as well do something productive while I'm waiting. I'll dress an envelope. Everyone remember how to do that? I wish I could e-file it, but I have to. I can't. So pain in the ass. Larry has a premiere at 4 p.m. Eastern, so it's bets after that. That is in no way helpful. All right. I'm 40% guilty only because 8 last time were guilty on some things. Yeah, that's enough reason to black pill yourself on this thing for sure, Travis. Yeah, that's a good reason to get to 40% right there. Just straight up black pill. Yeah, 20%, the 20% boost for black pill. I understand that, man. Apparently, Travis, we need to like collectively as the bar have a discussion again on the reasonable man, because apparently the reasonable man is sometimes a complete fucking idiot. When we were coming up with the reasonable man test, did we account for the possibility of the reasonable man being a fucking idiot? Because I'm not sure. I'm not sure if we did, and if we did, maybe we need to rethink it. Maybe the reasonable man test isn't such a good test after all, Travis. We need to rethink it. I'm going to write a law review article about the reasonable man is bullshit. That's going to be the title of my law review. How many alternates are there? 6 as far as I'm aware. This guy has a PO box. Of course he does. Wait, no. Who's the right? Who's counsel in this case? Let me check. Who is actually counsel? Let's double check. So I send it to the right person. Because I got to send them a copy of my notice of appearance. So it'd be really helpful if I make sure I send it to the actually right guy. I should probably check this in Pacer. Who is representing who? Okay, that's the one. All right. That cannot really be his name. Really? The attorney's name is Dennis Dennis? Seriously? His name is Dennis Dennis. What? Yep, that's his name. His name is Dennis Dennis. What the fuck? All right. It's spelled differently, though. His first name only has one end. His last name has 2. Unbelievable. Where did I put my stamps? I had them. What did I do with them? I'm going to use these wonderful shaker design stamps because they're cute. Better Rose on a Zero Fucks tour. If Better wants to join the stream, he's welcome to before I sign off. Is he available? Okay. Eastern. 4 p.m. Eastern. Okay, so it's 3 p.m. my time. All right, cool. Let's set the stream. All right. Let's set the stream. Try to push me in touch with Ryan Grimm. I'm not sure who that is, but I appreciate it. Okay, we need where's my thumbnail? I know that my mods created one. Where's the thumbnail? I know my staff created one. I saw it. Where'd it go? I can't find the thumbnail. Where'd it go? Okay, there it is. Thank you, Tony. Okay. Yeah, Ryan Grimm, that sounds cool. Yeah, J.E. Walsh. If you manage to get that done, then let my mods know and they'll tell me. Okay. So tell my mods on Discord if you manage to get that up or something so that I can like be coordinated in one place. What am I trying to do right now? I'm trying to create the stream for this afternoon. All right, let's see. We're going to schedule this. I'm going to call. Schedule stream. Okay. Karen Reed discussion with DUI guy. All right, that's going to be today. It's going to be 4 p.m. Eastern time, which is 3 p.m. Central time. Put in a thumbnail. Great. Good. Streaming is still not allowed on TikTok. The drama continues. Okay, do this. 3 p.m. today, create event. Anytime it wants to create the stream so that I can redirect it would be fine. Thank you. Okay, redirect setup. Great. Now I get to end the stream. I will see you in 2.5 hours. Until later, my friends, I've been Uncivil Law. Hope you have a great one. Cheers for now, my friends, and goodbye.